Please call the list.
Item number 1. In this matter, petitioner is old lady, senior citizen. She does not would like to proceed with the case.
I'm applying for respondent number 4.
Private respondent. And application can one?
It is also the same.
Madam, we have
Matter was out
the application.
settled outside the court and can be dismissed for non-prosecution. Withdraw the case.
Issue. At the time of call, learned advocate representing petitioner, or at the time of call, learned advocate representing petitioner submits on instruction that petitioner does not intend to proceed with the matter. Stop. An application being Can 1 of 2026 is taken out. Is taken out, thereby seeking leave to withdraw the writ petition. An application being Can 1 of 2026 is taken out in this regard. Stop. In this regard. Stop. Next paragraph. Respondent number 4.
My lord, I am led by Mr. De. I am led by Mr.
Led by
Mr. Tirthankar De. Mr. Tirthankar De.
respondent number 4
Respondent
is represented by learned advocate. Next paragraph. In view of submission made on behalf of petitioner, writ petition stands dismissed on the ground of non-prosecution. Accordingly, application being Can 1 of 2026 is also dismissed on the ground of non-prosecution. Stop. Accordingly, application being Can 1 of 2026 is disposed of.
Grateful to your lordship.
Parties to act on the server. Be next.
Grateful to your lordship. Item number 2.
Lordship, Mr. Rakib Hussain Khan is appearing for the petitioner. I'm only praying for a short passover. Mr. Rakib Hussain Khan is appearing for the petitioner, Your Lordship. I'm only praying for a short passover, Your Lordship.
The last occasion, where is he?
He is engaged in another court, Your Lordship.
Issue. At the time of call, accommodation is paid for on behalf of the petitioner. However, state respondents are represented by learned advocate.
Private tribunal ID is appearing for private respondent number 6 and 7. Lordship, taking short
Private
pass.
respondents.
He is of the lordship kindly taking short pass.
However, state respondents are represented by private respondents. However, state respondents are represented. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 6th August 2026. Next.
Item number 3.
Yes, my time for the petitioner. Today, we are supposed to file the report whether the girl has been recovered or not. There is an earlier direction by your lordship, my lord.
রিপোর্টের কপি ফাইল করে না কি করবেন একজন করলো তো
Yes.
The girl couldn't be traced out, but the persons who are involved in the offense,
Traced out.
they have been arrested.
They have been arrested.
They have been arrested. The victim girl,
Girl is traced out.
no,
No, my lord. That is the
raids have been conducted in various places.
Yes.
Raids have been conducted at various places, including out of the state as well, but no fruitful result is being there.
Very well, I am adjourning the matter for 4 weeks. In the meantime, let the efforts be on
We'll get
so that girl can be traced out. Issue. in terms of the order dated 2nd July 2026, a report, a communication dated 30 July 2026 of officer in charge, Belda Police Station, is filed today and same is taken on record. Next paragraph. However, Mr. Sujanil Das, learned additional government pleader, representing state respondents, on submits that several raids were conducted including raids outside the state, outside the state, but girl is yet to be traced out. It is all stop. It is also submitted that certain. It is also submitted that arrests are some persons have also been arrested. Next paragraph. Next paragraph, as it appears from communication dated 30 July 2026 that till date girl is not traced out, concerned police authorities are directed to make endeavor to find out to trace out girl. Stop. Hearing of this matter stands adjourned. Let another report be filed on the next date. List the matter under the same heading for further consideration on. Second September 2026. Great. Next.
Get item number 4.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Whether state is represented? No.
No, Lord.
Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 5.
Like they to appear for the private respondent husband. Last occasion when they have took an adjournment, have not served the state.
At the time of call, no one appears for the petitioner and no accommodation is paid for. You are for private.
For the private husband. Respondent number 5.
However, respondent number 5 is represented by learned advocate. Next paragraph, writ petition stands dismissed for default. Parties to act on the server copy. Next.
এখন কি হবে?
Item number 6.
Lordship, in item number 6, I appear on behalf of the state.
Yes.
I am for the petitioner, my lord.
দিয়ে দিচ্ছে নামটা দাও।
My lord, actually, case is one person sell his land to another person.
One person.
One person sell his land to another person, and a registered deed was completed. Thereafter, my lord, when mutation is going on, the seller, who is private respondent here in the name Tirthasankar Kole, he went to the BLRO office and threatening to the petitioner that he will kill him, and obstructed from the and my lord, obstructed from the mutation, my lord.
My lord,
Just a minute.
And my lord,
Just a minute.
GP sir আছে।
Yes. What is your instruction?
last occasion, my lord, as the state advocate was not present when the matter was called, my lord, your lordship have assigned the matter to me on that day. Now, my lord, they are present as your lordship direct.
Yes.
Now the state advocate is present.
My lord, we are led by learned GP, my lord, in this matter. Instruction has come, my lord.
Why last occasion nobody appeared?
My lord, I was in another court.
Yes.
I was in another court, my lord. I missed the.
No arrangement was made. Nothing.
I'm sorry, my lord.
And court had to pass an order, and now you are saying you are appealing for the state. Is it as per your ipse
No,
dixit?
my, no,
Then-
my lord. Not at all, my lord.
Yes.
Lordship, it is a.
Yes. What is your instruction?
My lord, it is. We have been instructed that there is a civil dispute between the parties, my lord. And
So you are being prevented from taking steps to get your land mutated in your name.
yes, my lord.
So you approach the appropriate bench for mutation. If your mutation is denied, What police authority will do?
My lord, actually, uh, mm, my lord, see the registered deed, page number 18.
Whether any FIR has been registered?
No, my lord, NCR has been registered.
You have prayed for investigation by registering FIR to register appropriate criminal proceedings.
Yes, ma'am.
So how that is permissible before the High Court? Then you have to approach the jurisdictional magistrate.
My lord, responded continuously stating the petition. Continuously, my lord. Lord, complaint is page number 48, my lord. 48. And registered date is, my lord, 18.
With regard to cancel status present and please.
My lord, petitioner is the
Status for the civil court status.
Grateful.
Item number 7.
Lordship, I'm praying for short Passover. Rajdeep,
Lordship, I am appealing for the human rights.
Lordship, Mr. Shobhasati Chatterjee appearing in this matter, Lordship. He is engaging in Lordship, he is engaging in code number 1, Lordship.
August. Item number 8.
My lord, I'm for the petitioner, my lord. The service was not effective. I'm praying for not this week, my lord. Faithful man.
Item number 9.
Lordship,
I am appearing for the petition in this matter.
Lordship, in this matter, Lanet AG is appearing, Lordship. Kindly make it
My
short.
lord, I am
On
appearing
his
for the
leg,
petition.
Lordship.
Lordship, he is coming, Lordship. It's on legs in another court.
My lord,
Lordship,
I
kindly.
can't hear you. My lord, I can't hear your lordship's minute.
Yes, yes, Mr. Banerjee, on behalf of CBI, accommodation is spread for. Let it be in the next week. CBI too was directed to inform this court whether any other proceedings are pending against the petition.
Yes, my lord, no problem, my lord. Let it remain, my lord, in it under this heading. Only one thing just
Yes, yes.
only one thing I want to inform your lordships. My lord, this order was passed on 14th July. And we also lost a complaint which was registered. On 21st July morning, the police station called him, the petitioner, for identification of a person. He went there at 7:15 because on 21st July, the program was there. And on 7:15, he went there, he was delayed. Thereafter, he was arrested for a new case by the state. And the magistrate has passed an order in his favor. Bail has been granted. And for one incident, repeatedly FIRs are being lost and he is being arrested. Therefore, we have prepared a supplementary affidavit also annexing the copy of the order of the magistrate. And every day, and very kindly remember, 21st July was a martyr's day. And he was supposed to come as a district president there with his workers. And since he was supposed to come, he went there 7:15. Early in the morning, they called him. And from 7:15, detained and thereafter arrested. But this is the thing is going on.
Well, issue affidavit service filed on behalf of supplementary affidavit filed on behalf of the petitioner is taken on record. Next paragraph on behalf of CBI accommodation is paid for. Stop. State respondents.
Lanet AG, Mr.
Which
Raj.
for the state.
Lanet AG, Mr. Raj Muzumdar is appearing in this matter.
Where is he?
He is on his leg, Lordship.
You are not appearing for the state.
Yes, I also.
State respondents are represented by learned advocate. Next paragraph, hearing of this matter stands adjourned. Stop. List the matter under the same heading for further consideration on. August 2026.
Develop this.
Next.
Item number 10.
I appear for the petitioner. ওই অর্ডার হয়েছিল।
Yes. What service complete?
No, Millard, last update by the postal department is on 23rd. We have Millard sent immediately. Millard, otherwise, Millard, if Millard matter is adjourned, my matter becomes infructuous. If your lordship want, I will delete the private respondent. I tell you, lordship, what has happened. Millard, this is Millard a tea company. Now, Millard, in the Millard Uttar Dinajpur. Now, they have a Millard garden, and on the part of the garden, Millard, their office space, and these are there. Millard, these private respondents, Millard, instigated by a political party, Millard, a political leader, Millard, all of a sudden, Millard, they entered one day, Millard, twice this has happened, and Millard entirely ransacked the office, Millard, tea bags were looted, and now, Millard, as of today, we being the owners, Millard, is completely, Millard, out, Millard, we cannot enter our, Millard, we cannot run at all. We cannot enter into our office at all. Millard, this is
So
the situation.
Private respondents have seized your garden.
Almost, and Millard, they are camping. Millard, if your lordship would kind enough to see.
My lord, police have inquired, my lord. There were some disturbance there, my lord, but police have taken all actions to maintain peace and tranquility. And my lord, I've been
Merely maintaining peace and tranquility will not do.
my lord,
Police authority has to take proactive steps so that the owners of the garden can run his garden.
my lord, there is a status quo, my lord, passed by the cities, by the civil court, my lord. This is,
In this
I have,
show me that order.
my lord, I do not have it, my lord. I've been
At
instructed.
least not our instance. We have not approached this civil court.
Status quo by the civil court, then let it be placed before this court.
My lord, kindly gives me 1 day's time, my lord, so that I can take a proper instruction with, because this is the current development which I have received, my lord, that because last time I had received that instruction that police has taken all that.
Very well.
You, in the meantime, you
I
try
will
to
also take
complete
instruction.
service. That's why service is
My
necessary.
lord, we have sent it immediately, my lord. There is no, my lord, update from the postal department till after 23rd. Kindly see.
Affidavit of service. So take back your affidavit of service. It is not complete.
Very
Matter is taken up for consideration, though service of notice upon all the respondents is not complete. Next paragraph, Mr. Bhattacharjee, learned advocate representing petitioner, prays for early hearing of this matter in view of urgency. Since it is alleged that tea garden of the petitioner is virtually occupied by
the private respondents and a mob.
By the private respondents and local goons. Stop. At present, petitioner being the owner of the tree garden, you are the proprietor.
Yes.
Petitioner being the owner of the tree garden is not in a position to run the said garden, requiring intervention of the concerned police authorities, which would permit the petitioner to run his establishment. Next paragraph, your name?
My lord, Guddu Singh.
Guddu Singh. Mr. Guddu Singh, learned advocate representing state respondents on instruction submits that steps have been taken by the police authorities to maintain peace and tranquility at the local, but there is an order passed by the civil court directing parties to maintain status quo.
Civil court
However, copy of the order of civil court is not placed before this court, and accommodation is paid for. Next paragraph. In order to accommodation is paid for. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on Tuesday next, 4th August 2026.
Grateful.
Yes,
Next.
Great.
Next.
Item number 11.
Entered your appearance, come back. Yes. Next.
My lord, I am appearing on your petition.
Entered your appearance, come back on the next date. Yes.
I am appearing on behalf of petitioner, my lord. Item number 11 and 20, both the matter are similar, my lord. Kindly fix the matter.
No, sorry, to the matter. I will not permit this.
My lord, both matter.
Where is the petitioner? Are you ready to place the matter?
My lord, kindly fix the matter along with item number 20,
I will
my lord.
hear it separately. Place the matter.
My lord, then give me some short passover.
In respect of whether you have deposited court fee.
Yes.
Show me the papers in support of your court.
My lord, the paper is not with me right now. Senior is coming, my lord. Kindly.
At the time of call, accommodation is paid for, and no document is shown that court fee is paid in terms of the leave granted by this court on 14 July 2026. Next paragraph. You are for the state. Yes. State respondents are represented by learned advocate. Stop. Hearing of this matter stands adjourned. List the matter under the heading motion in the monthly combined list of September 2026. Next.
My lord, in this matter, I am appearing
For the petitioner in this matter.
of India.
In this matter, my bank account was frozen. Pursuant to your lordship's last direction, my lord, on 29th, my lord, yesterday, my lord, I received a notice that my bank account has been unfrozen and lien of 1750
Disputed amount has been kept on hold. The disputed amount has been, my lord, kept on hold.
Instructions, my lord.
Your lordship. Yes. Right.
Yes, what is your instruction, Mr.
I
Shaha?
have submitted, my
My
lord,
lord,
the
the
notice from the
disputed
bank.
amount, there was a complaint from the NCPRC portal, my lord, that the transaction of 1750 was a disputed amount. So, my lord, that amount has been kept on hold. Otherwise, the account has been.
What is the amount?
1750. 1750.
In that event,
That is there in the email from the branch manager, my lord.
just a minute. So, this from So disputed amount is 1750.
Yes, my lord, it is there in the complaint as well. I have annexed it.
So now you are in a position to operate your bank account.
Yes, my lord.
Issue. From the submissions made on behalf of the parties, from the submissions made on behalf of State Bank of India as well as petitioner, it appears grievance of the petitioner is redressed. Stop. In reference to one email letter dated 29 July 2026, issued on behalf of branch manager State Bank of India Shoshuna, petitioner was informed this letter was sent to you.
Yes,
Petitioner was informed that disputed amount, that is a disputed sum, that is rupees 1750, is marked as lien in connection with bank account of the petitioner lying with State Bank of India Shoshuna branch. It is also submitted that petitioner excluding petitioner excluding sum of rupees 1750 shall be permitted excluding 1750 shall be permitted to operate account and said account is defreezed. Stop. Next paragraph, in view of steps taken by the concerned bank authority, no further order need be passed on this writ petition. Stop. Writ petition is disposed of. Parties to act on the server copy.
Grateful, my lord.
Next.
May it please, my lord.
Item number 13.
I appear for the petitioner here.
13, my lord, I'm led by, my lord, the learned Solicitor General of India and the learned Additional Solicitor General of India. But Raju sir is online, but SG sir is on legs. So
Let the matter be
I can address.
Let the learned advocate starts his submission on behalf of the petitioner.
Raju sir is leading me, but he's their version.
My lord, I have a preliminary objection. I have a preliminary objection, my lord.
Yes.
The preliminary objection is that this petition is not maintainable because of clubbing of several different causes of action. Number one, it is also not maintainable because what is asked is an omnibus general blanket order, which is also not permissible in law.
Yes. Second point I couldn't follow.
The prayer, some of the prayer says for omnibus blanket prayers that grant me relief in any other FIR, any other proceeding. Such type of relief is not granted. There are several judgments of the Supreme Court on which I am placing reliance. So two things.
No, if this court restricts its consideration to 3 of the FIRs where particulars are disclosed in the writ petition,
then, my lord, he should file 3 petitions. He can't file.
If you come to Mr. Raju, if you come to paragraph 13, if I'm not wrong, not paragraph, page 11.
Page 11.
The table which is provided in page 11 and 12.
Yes.
Yes.
Please come to page 11 and 12 of the writ petition.
Yes, madam. Give me a minute.
There are 8 criminal prosecutions which are indicated in the table, out of which you will find that apart from serial number, just a minute, serial number 1, serial number 2, serial number 3, and serial number 4, particulars of FIRs of so far 5, 6, and 5, 6, 7, 8 are concerned are not provided. So at this stage, court is not required to go into the niceties of those FIRs which are against serial number 5, 6, 7, 8. So court will restrict its consideration and exercise so far 1, 2, 3, 1, 2, 3, and 4 is concerned.
My lord, may kindly, therefore, I'm obliged, my lord, kindly look at the prayer clause, para 102, at page 92 of the petition, my lord.
It's only for these four. It's only for these four.
Yes.
Yes.
Now look at, his prayer is restricted. Kindly have a look at prayer B, my lords. Issue writ in the nature of mandamus commanding the respondents and their men, agents and assignees to show cause as to why Bhawanipur Police Station 121 or 26 shall not be quashed. The first is to quash the Bhawanipur FIR. Second is issue writ in the nature of mandamus commanding the respondents and their men, agents to assign show cause why Siliguri Police Station dated so and so.
Mr. Raju, if I may, my lords, the prayers that I'm pressing are from prayer G onwards.
So
Today
not
I'm pressing only from prayer G onwards. Those
Yes.
are the main prayers in the writ. The interim prayers are from
But
G
the main prayers are in support of the interim prayers.
That is
are in
true.
support
That
of
is
main
true.
prayer.
The
So
reason,
unless and until your main prayer cannot stand, interim
Yes.
prayer also
no,
fails.
that's the reason.
Therefore,
Yes.
the points which are being
Let it be
agitated,
recorded, my lord. Let it be recorded that till prayer
I'll
G is
answer
I'm sure
each
this is
of
a valid point.
I'll answer each of them.
Because
That's no problem.
divorce this
Yes.
main prayers,
Yes.
interim prayers cannot be considered.
There's no doubt. But I just want to clarify that what I'm pressing today is prayers G onwards.
No, it's not a question
And
of
the
today.
reason why
That is the interim prayers.
Yes, and the reason why prayer G is significant is because
Yes.
the documents underlying some of those complaints, the particulars of which are not with us, are the ones we're soliciting by way of prayer G.
Just
Which prayer G, if I may read,
No, my lords may kindly
statement
I'm
of
not
certiorari or any other appropriate writ order or direction be issued, calling for the records relating to the aforementioned cases and other complaints against the petitioner. At the time of filing this petition, we had
particulars of four criminal prosecutions are not
No, no.
before the petition.
No, the
are not available to the petitioner.
they're not available. So now what we have is we have filed a supplementary affidavit last week.
In order to know the particulars of those.
Correct. Some of those which had been at complaint stage, we now have the FIRs of them.
We have not been served
And-
with any supplementary affidavit.
But supplementary list is not served on us.
Very well.
Supplementary list is not.
That we can hand over. In any case, as your lordship said, I will deal with these prayers, and if Mr. Raju is done, I will answer his preliminary objections.
Now, Mr. You are Mr.
Shankar Narayan.
Shankar Narayan. Now, Mr. Shankar Narayan, if today court passes an order directing the authorities to provide particulars of those criminal prosecutions,
Yes,
which are not disclosed in this writ petition, since it were not provided, these were not
Yes.
provided to the petitioner. In that event, then these particulars be provided and then let a date be fixed.
So no, I'll just allow me to just say, my lords, what our concern is, and if I may first.
In spite of directing the state respondents to provide particulars, you will press your writ petition so far the merits, which will be restricted to 4 criminal prosecutions where particulars are provided.
I will expand a little beyond that, if I may, and I'll give your lordships the reason why. If I may just answer that. On the first point, which was taken by Mr. Raju, saying that you need to file multiple petitions one by one for each FIR, that aspect has already been considered, and there are 4 judgments of coordinate benches of this court in an identical scenario. Now, I will confess fairly, because I'm an apolitical man, that the boot is firmly on the other foot. And that's why a little bit of a history reminder to Mr. Raju is relevant. In 2021, on 2nd May 2021, the results of the Legislative Assembly's elections in Bengal were declared. As a consequence of which, when the party came into power, at that point, it was the TMC, of whom I am the National General Secretary, the petitioner before your lordships. At that point of time, a series of FIRs came to be registered against a political opponent and his associates. That political opponent happens to be today the Home Minister of this state. At that point of time, I know, but what is relevant today is Home Minister. At that point of time, petitions came to be filed in this court. Each petition had lists of FIRs in them. 17 in one case, 44 in another. In each of those cases, at the motion stage, your lordships were pleased in separate cases to say, look, looking at the timeline from 2nd May 21 to now in July, all of which are mirroring the timeline which are there in this petition today. We feel this is a violation of Article 21 that A, suddenly a whole bunch of FIRs come to be registered with substantial delays. B, there is no explanation for any of these delays. Many of these are not even crimes or offenses that are made out. C, doing this in such a sudden manner, one after the other, is a clear violation of Article 21.
No, he's arguing on merits. He's arguing on merits. My
FIR.
preliminary objection.
Spate of FIR.
After publication of a result.
After publication of
After
results.
result
Yes.
was declared.
Yes. And there were no criminal.
These FIRs and the alleged incidents are connected to incidents which took place long back.
Long back and separate incidents. They were not the same incidents, separate incidents, multiple incidents. So in those cases, your lordships entertained them at the interim stage. At the interim stage, you granted the following reliefs. I'm not using this as any binding precedent. I'm saying this is the fashion in which where political disputants start filing FIRs against each other after election results. The court's approach has been this. And under Article 21, I think it's a fair approach.
Mr. Raju.
Yes.
Mr. Raju.
Yes. Yes.
There are
Yes,
orders where multiple FIRs were, though this point was taken by this court on last occasion, but there are orders where multiple FIRs were taken into consideration while in a petition seeking quashment of those criminal prosecutions.
I'm obliged.
So,
I'm
there
obliged.
is
Now,
no
kindly have a
use
look
of-
at para 9.2
use
of
of
that order.
sending,
Kindly have a
directing the petitioner
9.2 of that order.
to file separate writ petitions in connection with different FIRs. Because the prayer at the
Now, I'm obliged.
end of the day, Mr. Raju, is that petitioner is praying for protection during continuation of investigations in connection with criminal prosecutions.
Now, my lord.
Taking note of the nature of prayer couched in this writ petition, let this issue be considered in one go, instead of directing the petitioner to file one after another writ petitions challenging different FIRs and which will lead to multiplicity of litigations.
No, my lord. I'll tell my lords why. It is not as if the 3 or 4 FIRs which my learned friend is assailing in this petition relate to a same transaction. The judgment which my learned friend is referring to, or the order which my learned friend is referring to, is a 2410-25 order in the case of Suvendu Adhikari. My lords, may kindly have a look at para 9.2, and it is an interim order.
No, that's not what I'm relying on.
But that point was
I'm
not
relying
even
on-
touched.
Just excuse me. I'm relying on
Every
three.
time my learned friend interferes, I never spoke a word when you were
No,
arguing.
because you're attributing to
Let
me a
make my
submission I did not
You'll
make.
get a right. You'll get a right after I finish. I'm sorry.
No, I don't need your
You don't
permission.
have a right to interject every time I make
There
a
are
submission.
3 interim orders I'm referring to, which are
good.
8th July 2021.
But
In
look
fact,
at
4.
the judgment, my lord.
4.
Interim orders, but it all
Four
in the
Interim
judgment.
orders are not
Yes,
judgment.
Mr. Raju, which paragraph you are relying upon? From the
9.2, my lords. There are 9.2.
9.2.
Yes.
That's the final judgment.
2410-25. Get those judgments. Interim orders.
That's a final judgment quashing the affairs.
Now, kindly have a look.
It's okay. It's even better.
As contended on behalf of the petitioners, my lords have got it. Thereafter, this issue was not taken up as a separate ground of non-maintainability.
Yes.
The respondents participated in the hearing till the end, and thus should be stopped from taking this as a ground of non-maintainability at this mature stage. So that was on facts. At the fag end of the argument, they took up this. I am taking it at threshold. That's the difference. So this judgment is on facts, distinguishable, that cannot apply. Now, there are a large number of judgments which have taken the view that interim orders are not precedent. They can't.
That's the judgment in the quashing where they quash the FIRs. But that's not
Doesn't
the
matter.
judgment I'm relying on. I'm relying on other orders.
I'm addressing Mr. Gopal Shankar Narayan. You have had your turn. Don't
No,
be
I haven't,
impatient.
Mr. S.V. Raju.
Every time I
I'm
make
still
a brownie
addressing.
point doesn't mean that you will stand up and argue. Let me make my points.
I can't sit
don't
down
interrupt
like you
when
and
my
argue.
points are not made. I'll address on each and every judgment that you have cited.
Either he's
No,
made
let me
the
argue.
preliminary objection and he
Either-
wants me to answer it,
No.
or he hasn't.
I will answer. Now, my lords, as far as interim orders are concerned, they can't be cited as precedents. Kindly have a look at 2003 6 SCC page 1. Since my learned friend has made this submission at this, now only I have not handed over a copy of the judgment, but the judgment is 2003 6 SCC page 1. Which para is it?
Let us stapler down to.
This is extracted, my lords.
Yes, you are relying upon 9.2. Apart from 9.2, what are the other points which you want to urge before this?
Other points are the other judgments on which my learned friend is relying have no precedential value. They can't be relied as precedent because they are interim orders. Supreme Court has said umpteen number of times that interim orders cannot be cited as precedent. They have no value either. They have no value so that they can be relied upon. Now, kindly have a look on this point. As far as the main judgment is concerned, this point was not there. Now, as far as interim orders are concerned, kindly have a look at this judgment which I have cited, my lord. To the para. That is.
You can do the second one, sir, which follows.
And the second judgment is, my lord.
Where is the second judgment?
Yes. 2009 5 SCC 694, para 21. Which follows this.
2005 SCC page?
Page, my lord, 694. 2009 5 SCC 694. Para 21.
2009 5 SCC?
694, yes, my lord, 694.
2009 5 SCC 694.
Yes, para 21.
Where is the judgment? Where is the hard copy of the judgment?
My colleague has shared, my lord.
No, that will not do, Mr. Bhattacharjee.
Very good.
I have to
He
consider
made the submission now, my lord. It was not there earlier. He made the submission now, therefore I'm referring to this right now, my lord.
It's your preliminary objection.
বইটা আনা 2003 6 এসএসসি আর একটা বল
My lords have got para 21 of this judgment, my lord.
What is the proposition of this judgment 694?
What is precedent, para 21, an interim order which does not finally and conclusively decide an issue cannot be a precedent. So interim order cannot be a precedent. It can't be relied upon. It can't be shown and say, I'm relying on it. And they have placed reliance on Kapila Hingorani, that is 2001 7 SCC.
Narayan, problem is this, in Shubhendu Adhikari's matter,
yes,
it is true that at the motion stage and finally the multiple FIRs were taken into consideration and order was passed. But at the threshold, this issue this point was not agitated. Now, that's why a finding was returned in paragraph 9.2 of the final judgment, that if this point would have been taken at the right point, at the right moment, in that event, separate petitions could have been filed. So therefore, an interim order which was passed is not a binding precedence, especially the issue which is being considered by this court.
Fair enough, that was in fact
an interim order, and where this issue was not agitated.
That was my response, in fact, my submission, that it's not binding on your lordship. That's what I said myself. And if I had not been interrupted, I could have satisfied your lordships entirely. I have three responses. The first is this: 9.2 has been shown to your lordships. Why has 9.3 not been shown? Let me read 9.3 of the same judgment to you, if I may. Would your lordships have Shubhendu Adhikari's that final judgment?
Yes.
Yes. 9.3, which is the next paragraph, reads as follows: the issue of joinder of more than one cause of action in an application does not, however, go to the root of the matter, or for that matter, raise a question of jurisdiction per se. Even if separate applications were filed here, the same could have been, and in all probability would have been, taken up for hearing together as they involved similar issues and questions of law. This is the proposition. This is the finding of law. And today, I am not concerned with who is the person in government. The state did not take this matter up in challenge. They have accepted this proposition of law as binding
There is
them.
an appeal which is pending, my lord.
Not that I
There is an
know.
appeal which is pending, my lord.
Not that we know.
Pendency of the appeal.
No,
will not,
it is being submitted that the state did not take it up, my lord, but there is an
will
appeal.
not
was told there was
obliterate
no
the proposition of law which has been
An appeal is pending. I will find out
declared by the coordinate bench.
I am just stating the
our-
correct facts, my lord.
To our
There is
knowledge,
an appeal
this
which is
has
pending.
not been challenged, and in any case, this has not been stayed, and this is a binding proposition.
Appeal
Apart
number
from that,
And Mr. Raju, instead of going into this technical issue,
correct.
point is this, that today, if I direct the petitioner to file separate writ petitions, and this writ petition will be confined to out of one criminal prosecution only, then within a week, 3 other petitions will be filed challenging the criminal prosecution.
In fact,
Doesn't
between the
matter,
last,
may not
will be
be-
what
but that
purpose would
is
be
a
served, sir?
procedure.
between the
What
last
purpose would be
hearing
served,
and
sir?
this, they've registered 3 more
Purpose
FIRs.
would be that the law which says that you can't have a petition for 4 different causes of action, the purpose will be that you will be abiding
There
by
is
the
no such
law.
law.
No,
which
it's
requires
it is
that-
Mr. Raju, it is an hyper-technical
It
point.
is,
Let me
it
consider
is.
the matter on
Let me
merit.
I'm grateful.
Yes.
I'm grateful. Now, if I
Yes.
can,
Now, my lord,
if I
kindly
can
have a
just
look
address your
further.
lordships
My
on what.
Let,
second- my
let
second-
us come
Yes.
to the merit of the case.
Yes, charts.
Yes.
Now,
I'll just
my second,
address
my
your
second
lordships now on the
preliminary
merits.
objection.
Let's
This
go
is
to
not-
the
Permit the
I have a
petitioner to
second
place the case,
preliminary
Mr.
objection.
Raju. Yes.
I'm grateful, Manoj. I just
Preliminary
to make it
objection, my lord.
convenient for your
Yes.
lordships, I have put it in a chart. So if your lordships can see in a chart, we have given the reference page numbers where it's referred to in the affidavit, to our knowledge.
Thank you.
And, yeah. Anybody else? Yes. Okay.
A copy may be given to me.
Yes, I've given it to your friend.
Give me a
Uh,
soft copy, please.
Now,
You have a soft copy?
the complaints in all, my lords, are 11 in number. If I may, I just want to give a little bit of a backdrop.
No, complaint as per your page
Yes. I'll go one
11 and 12, there are 8 complaints.
at the time of filing the petition. Now, your lordships were kind enough because my friend appeared and he said we will file a status report.
I never said so, my lord. It is something they are trying to attribute.
I was present on that day. It
May
was
have been
pushed off
present.
only for that reason. In any event,
I never
any
said,
event-
no, I said that I am yet to receive all the instructions.
very well. In any event, what has
They cannot put
transpired?
word in my mouth.
What has
There is no
transpired?
prayer also to that effect.
What has transpired between that day and this is that there have been further FIRs that have been registered. The situation is thus, that between the time that the election results were announced here in Bengal on the 4th of May 2026, your lordship will recall I mentioned how on 2nd of May 2021 election results were announced. Within 3 months, a host of FIRs were registered against political opponents. At the interim stage, in 4 separate interim orders, the court stepped in and said, stop doing this. No more coercive steps. We are staying these FIRs proceeding. We are also requesting you that any further FIRs you're registering against these petitioners, you will come and take the leave of the court. Those are the 4 orders. I haven't placed those yet. Mr. Raju is referring to the final judgment in just one of those matters, where we have just pointed out these 9.2 and 9.3. Now, complaint-wise, from the details that we have of either the complaints or the FIRs from the websites of the state government, the details that we have are these, my lords, in this chart. Which is why, if I can just take your lordships one by one. The first one is this 27th May 2026.
Yes.
With the supplement.
What have you given, my lord? The previous one. I'm so sorry. I understand there has been some mix-up at our end. We have given you a wrong chart. Can I give you the proper one?
This date of offense is 2nd May 2026. It's a
Second.
contemporaneous FIR, Mr. San.
4th May was when the elections were. That chart, my lord. I'm so sorry. Yeah.
But I will keep it.
Yeah. This is the final one?
Yes.
Yes. 4th May 2026. Your lordship may just note in pencil at the top left hand that date, 4th May 26, because that's relevant. Immediately thereafter.
Where 4th May?
I have not put that. That's the date of the election declaration. I'm just pointing out the timeline. That's relevant. So the first complaint is of 27th May 2026.
You've given me a different chart, I think.
Just
The font.
Check with him.
Especially in
That's
this
right.
determination, you need not write it down. The date of election, declaration of election.
I find it
This
very
is the nature of matters which have been considered by this court.
my heart is with your
Yes,
lordship.
yes, yes.
I find it so difficult that one has to even deal with these kind of things. 27th May 26 is the first one where the complainant is one Mr. Arnab Das. The complaint which is made after
This is serial number 1, FIR dated 27 May 2026.
Yes.
Arnab Das, right?
Yes, Arnab Das. The date of the alleged offense is the second column, which is, it's from the FIR. The date of the alleged offense is 2nd May 2026. So no explanation as to why suddenly they waited so long, except perhaps the election.
Why it is so long? 27th May date of and the
Correct.
offense is 2nd May.
Correct. That's what they have to answer as to why they allowed an FIR to be registered after that span of time. Perhaps because of the change of government in between is the perception that we have. Now the delay is
gap is 25 days.
25 days. That's a
Not
third.
much.
No, well, if your lordship sees what the allegation is, then the question may ask, why did you wait 25 days? So the allegations, your lordships will see, are under 196 and 353. It is the complaint that posts on X promote hatred between communities, referred to the exact phrase that is used by the petitioner in a tweet that he's put out is that the Bangla Birodi Gujarati gang, not all Gujaratis, only Bangla Birodi Gujarati gangs. Now, the use of the word gang has incensed the complainant. To say that this is trying to create divisions between communities and attracts the provisions of 196 and 353. The exact tweet, the entirety of the tweet, only for the context, I'm just handing up what the actual tweet is, because that was not annexed with the complaint. Your lordships can read it. I feel it's political speech. I don't want to read it out to your lordships. Please read it as your lordships will. This is the statement that is made. Now, this is made on 2nd May. Election results have not yet come. A political person who's the general secretary is making this statement. Now, this statement is not immediately
handed over like this, for it's not in the petition, my lord. My learned senior is my lord, online.
Just the tweet.
How do I do it, my lord?
The tweet
Papers
is
after
online.
papers, my lord.
The link is there in the petition. The link can be
Give copies of this paper,
yes.
which you are relying upon.
My lord, let them do this, my lord. Whatever document they intend to rely on, let them give me a copy. Let me scan and my lord, let me share it with my senior.
I didn't know that somebody would be appearing online.
They know it very well, my lord. On the last occasion also, my lord,
last
Mr.
time
Raju
also I
appeared.
appeared
When we
online. I'm
appear
sorry.
online, we never make this interruption, my lords. We allow it to be
No,
scanned.
no.
We all have
You are
phones. We
known for
scan and send it
interruptions. You are
immediately.
known
It's not
for
that much of a
interruptions.
problem. I
No.
don't think these should be reasons for interruptions constantly. Don't hand up anything more. We won't
My
give
lord,
out
may I only
anything more
request this, my lord. My
paper.
lords may keep it in the second
So,
session. I will have a look at the papers, my lord. My lords may
now,
keep it in after lunch, my lord.
These are the particulars of FIRs.
Yes.
I have to
And
share it.
sections
They have
which are-
Documents or charts,
which
my
are
lord.
incorporated
Yes.
in connection with FIR.
It's regarding this one tweet. This is the substratum of their FIR. It's not my FIR. It's their
My
FIR.
lord, my request, may
They should
I,
have given it to their councils if they wanted.
Yes,
my
Mr.
lord, may I
Raju.
only make a request? My lord, the matter may be kept in the second half, my lord. I'll come back with that.
No, in the second half, it
One
won't be
of-
possible.
Oh,
Different
Mr.
matters.
One
are
of,
scheduled
by
for
12:30, my lord, it can be kept at 12:30. 12:30 only. I have a matter which is called
Mr.
up.
Raju,
being
different
called in the
matters are
first
kept
court.
for consideration. I am hearing this matter at least for 20 minutes.
Yes.
Now I cannot adjourn it.
Yes.
Because
At the-
I'm
at
not
the
saying asking
threshold
for an
if- at the
adjournment.
threshold
I'm
if-
only asking for an
At the threshold, if you
accommodation
would
till
have-
12:30. I'm
at the
only
threshold,
asking for accommodation till.
You come back, your junior, is Abel Junior is there, Mr. Additional Advocate General is there.
Yes.
He is representing state.
He's here.
If you have any preoccupation, you can.
I'm called in the Chief
back at
Justice of
12:30.
India's court. My
But
first
since
court,
this
my
court is
matter is likely to raise.
hearing these matters for last 20-25 minutes, at this stage, there is no use of adjourning the matter. At the
I'm not asking for an adjournment. I'm just saying, let his arguments be over. I'll address my lords at 12:30. My lord.
Yes.
So the ground that we have taken in the last column, my lords, on this, it's just this one tweet, is that the mere use of the word gang cannot invite serious criminal sanction. You cannot criminalize ordinary political speech, which is made at the heat of an election, etc. And that the judgments we have relied on are Subramanian Swamy and Bilal Ahmad Kalu. Now, these are points we have taken if we were to take this FIR in isolation. But if we see a pattern beginning to form, and that pattern began to form because 6 of these FIRs and complaints have been seven have been initiated by one Abhijit Das Bobby. Serial number 3 is one of his. He stood against me in 2 elections. He lost against me in 2 elections, and then sets off on this spree of registering FIRs. From 3, your lordships will find serial number 3, 4, 5, 7, 8, and 11. Now, I will admit these all.
Now, there is one problem.
Yes.
In the writ petition,
Yes.
which is confined to
8.
8 FIRs.
That's correct.
Now, if you want to club other FIRs in the writ petition, then you have to file a supplementary affidavit.
We have a
That which is
supplementary
served upon them. Otherwise, court will not enter into the merit of those FIRs.
So, to be fair,
I will not permit you.
I fully agree. You should not permit me, and I will not therefore go into that right now. But what I'm saying is,
So then in that event, you have to restrict your writ petition so far the FIRs which are disclosed in the writ petition. Not beyond that.
That's I think fair. That's I think fair. We have a supplementary affidavit where the particulars now we have discovered, because now when you are dislodged from a political position and you're an ordinary citizen, getting access to these documents becomes very difficult. Which is why, as a
Now
supplementary
you have to take a decision that whether the supplementary affidavit, if you want to press it before this court.
Yes.
And thereby you want to add 3 or 4 more FIRs.
Yes.
Which are lodged or which have been registered against the petitioner in the meantime. In that event, let the matter be heard on a subsequent date. And
so may I say,
upon them.
I'm taking that call.
Filing the supplementary affidavit today, I will not permit you to enter into the merits of those FIRs which are not disclosed.
I'm not doing that. I'm not doing that. I want it to be clearly understood from my.
Then restrict your.
I don't
case
want.
So far the FIRs which are disclosed in the writ petition.
I'm doing that. I'm doing that, and I'm restricting myself to the prayers which have been made in the petition, because eventually, what I perceive happening, unless some interdiction comes from this court, is that every week more FIRs will come, and
because it is not a sole case so far petitioner is concerned.
Correct. It's not.
This court has granted protection to the petitioner in another case. At least 2.
Yes, your lordships have.
2 cases are there. One is
individual cases.
Writ petition, and another is criminal revision.
Yes, criminal revision. Your lordships.
So therefore, there are other matters.
There are. But because now this pattern started emerging, we didn't have a choice but to follow what has been entertained by this court in the past of coming with en masse as far as at least 8 at that point of time. Now, this supplementary affidavit, we will tender it, but I'm not going to rely on it today. They will at least have it with them so that they can.
Not have this.
No, I'm not pressing it today. I've made it very clear. Again making it clear. I'm not referring to the supplementary affidavit. I'm not relying on the complaints in the supplementary affidavit. I'm confining myself to the writ petition and the prayers made.
Supplementary affidavit.
No, that you can't restrain me from filing.
I'm submitting for his lordship. It cannot
We're at
be
a
piecemeal.
motion stage. No, it's not piecemeal. I'm restricting myself. So now, if I can take you to
Mr. Shankar, Mr. Shankaran, do one thing.
Yes.
Restrict your writ petition to the prosecutions, criminal prosecutions, and FIRs which are
those 8 which I have listed in the table.
It is not the sole petition so far the petitioner is concerned.
Correct.
There are other petitions.
There are others. Yeah.
With regard to other petitions, court will grant you leave to take steps in accordance with law.
Yes. So now.
So therefore, you need not file your supplementary affidavit in this writ petition.
Yes.
Restrict your writ petition so far the prosecutions which are disclosed in this writ petition.
Yes. So if your lordship sees 1 to 8, no, the first 8.
Otherwise, it will never end. Suppose today hearing is not concluded.
Yes.
A subsequent date is fixed.
Yes.
You have concluded your submission. Another FIR is filed. Then
That is
what
what-
will happen?
that's
Then you will file another supplementary affidavit.
That's the problem.
disclosing that FIR.
That's the problem.
And you
That
will,
can be
start your argument again.
so that can be taken care of by your
line
lordship's
has to
orders,
be
in
drawn
my
up.
view.
Yes.
Yeah, that can be taken care of. We can be
Yes.
protected by your lordship's
So
orders.
restrict your writ petition so far the prosecutions which are disclosed in the writ petition.
Very well.
Yes.
So then your lordships may see.
So no
overly-
supplementary affidavit, Mr. Bhattacharya. Yes.
No, we've taken it back, I think. So number 2, 12th June 20 in the chart. 12th June 2020.
Just a minute.
Yes.
Yes, 12th June.
12th June 2020.
Complainant Sanjay Singhal.
Complaint
Where
Sanjay
the
Singhal.
complainants are served.
No, they're parties. In the writs, they're parties. Their parties, have they been?
Show me that service has been affected upon the complainants.
Service has been affected?
Their details are not available. Because
No, are they parties?
What about service upon Arnab Das, Sanjay Singhal and Abhijit Das?
after service, it is.
No, but that, tell me if it's,
Service is every service filed on the last occasion.
tell me if the service is.
Every service to the দাও তো এটা এখান থেকে খোলো খুলে দাও let them scrutinize every service and satisfy this court the service was affected.
15th July 26 order of your lordship records that.
No, no one appeared on behalf of the on behalf of those respondents.
No,
who
our
are de
affidavit
facto.
of service. No, I'm sorry.
Yes, show me Mr. Nondi service affected upon complainants.
Just show the affidavit of service. No? In this unknown, when I have April 26th, here. What has been served? Where's the affidavit of service? Do we have it?
Yes. And if you go on enhancing number of FIRs which are being registered, and that is at the instance of different persons, then those de facto complaints are required to be made party.
That's
and
precisely
it has to be effective.
That's precisely the
Problem.
That's
Yes.
precisely the concern your lordships had when you passed those earlier interim orders to ensure that that doesn't happen. Said, please take the leave of the court before new FIRs are registered, because you may have multiple complaints. Each of these political parties, your lordship knows, have enough genuflecting, aficionados who are running around willing to go ahead and file a complaint. Eventually, it's the state that has to register the FIR. So at that stage, when it comes to registering the FIR, the leave of the court will be taken. That's what your lordships have said. That's what I'm relying on. Because otherwise, it becomes impossible for the citizen of this country to keep running after every single person who can possibly register an FIR and keep troubling the court. Eventually, my lords, this is beleaguering the court. Court shouldn't even be drawn into this to start with. Unfortunately, this is a political system we live in today, where I have to draw your lordship. Just the affidavit of service. Yeah. Just flag that. Yeah. I'm so sorry. We should have been prepared for this. Respondent 16. Okay. Hand that up. That's enough. Yeah, that's right. At least have shown a few. Yeah. Yeah, from the previous page, my lords, these three are the acknowledgements.
Deliver. Yes.
May it please. So back to the chart, my lords, where seconds, Sanjay singles. The dates are not disclosed, my lords, but what we understand is this event, this incident occurred sometime in April 2026.
Yes.
Incident we understand occurred sometime in April 2026. What is the incident? That apparently I made a statement. I will play the DJ so loudly that eardrums will burst, and last time we were lenient, but this time won't be. This speech, again in the heat of an election, comes to be registered on 12th June 2026. It's an incident of April 26. Again, immediately after election results, in 12th June, it comes to be registered, and this is the offense that is complained of. There's a second complaint.
The particulars are not available.
We don't have it, my lords. We have referred to it at page 11 of the writ. That's why my prayer, which I pointed out to your lordship, prayer H, saying, please give us what these particulars are. Prayer G, I'm sorry. The third one, this is by Mr. Abhijit Das. This vaguely refers to a period of 8 years from 2017 to 2025. This is taken from the FIR itself. 10-year period, therefore from 2017 it's happening. He is watching it as a public individual, makes no effort to move even the courts to register under 156(3), etc. Suddenly pops up in 16th June to have an FIR registered. And he says that I am involved in an illicit mining operation which damaged water bodies and stole government assets, etc. Gives a list of the people to be investigated, the long list. Now, there is no explanation as why this delay. At page 147, just for a minute, if your lordships will see that page 147 of the writ itself. This, in fact, is the complaint.
This is FIR number 135.
FIR, no, it's 140. 135 is the page number. 140, fourth column. Fourth column is 140. 140, yes. So the FIR starts at the complaint starts at page 135. And at page 145, for a minute, if your lordships will have. Yes, page 145 first. I'm not taking too much time. I just want to show the relevant parts. Persons whose role requires investigation. 145 towards the bottom.
145.
145, my lords. Persons whose role requires investigation. Your lordship have that? Yes. Based upon information received from local residents, field level inputs, publicly available information, and other circumstances requiring verification, I respectfully request that the role, if any, please mark if any of the following persons be examined during investigation. I am number 1. Now there's a long list. Please come to page 147, my lord.
This is the complaint.
This is on which an FIR comes to be registered. Page 147 again. Bottom of 147. Possible influence, facilitation, or protection requiring examination.
147.
147. Bottom of the page, that headline. Possible influence, facilitation, or protection requiring examination. That last paragraph, I don't want to read unnecessarily. I respectfully submit that para you can ignore. The next one. Without making any conclusive allegation in this regard, I respectfully request that the investigation examine whether any public servant, elected representative, politically influential person, intermediary, or other individuals facilitated the activities, assisted in obtaining unlawful advantage, influenced regulatory or enforcement process, provided protection from lawful action, or directly or indirectly benefited. So how could this become an FIR? You're not even making an allegation. You're saying, please investigate if.
Page 147 is also part of this FIR.
Yes. Same one. This is the complaint underlying the FIR, which the state thought was enough to impel them into registering an FIR about an incident which started.
It starts from page 136.
136. 135, 136, yes. It's 136, top right hand, your lordship will see received, dated 16th June 2026. We strangely have another copy which is on record, which has a different receiving, but I don't want to get into those nitty-gritties, my lord. Let's deal with it as it is. Page 136, it's addressed to the inspector in charge. Now, this is the complaint. Now, on the basis of this, saying admittedly that I'm not making allegations, the role, if any, of these individuals may be looked at. No specific allegation regarding me at all. Given a slew of people that you should perhaps investigate, an FIR comes to be registered. This is the FIR. This is the third one. The fourth one, by the same person, on 16th June, Mr. Das appeared to be quite busy on that day, because this is the second one of the same day. This, my lords, item 4, the incident takes place in May 2020. The delay is 6 years. And the allegations, your lordship can see all the offences put in. He alleges that we have misallocated public disaster relief funds via an unauthorized database for Cyclone Amphan. Firstly, these allegations are more than 6 years in the past. No explanation given as to why this delay. The allegation related to discrepancies in the beneficiary numbers, but no link with the petitioner is even alleged. There is no express reference in the entire FIR to any act or omission of the petitioner. And they don't anywhere disclose a prima facie offense. Now, I could read 20 pages of an unnecessary complaint to show you that there is no reference, but your lordships can take it. I've stated that it's there. The complaint starts at page 161.
Just a minute.
Yes, Manoj. Page 160 is the FIR 668. 669. At 160, Manoj.
160.
160. Your lordship will see top.
FIR,
Yeah,
normal
FIR.
FIR.
Yes. Date of FIR, top right hand is June 26. But in the third general entry reference column, general diary reference column, occurrence of offense towards the right, it says May 2020.
Serial number?
3 small b. Towards the right side, it says May 2020. Your lordships have that?
Yes.
So the FIR itself admits. The first question the cop should have asked is, excuse me, why are you coming after 6 years? What is the explanation for this? But he just diligently writes down May 2020, goes ahead and...
That by a person who lost the election twice.
Yes. This is the second of the same day. Of the same day. And the earlier one was at the Katyala Ashuti police station. This one is at Bishnupur. And the complaint follows from the next page onwards. And once again, he says, I want an impartial investigation. The kind of prayers we would make in a 226 petition is what is made here. And with reference to me at page 163.
That is the page, just a minute.
160 was the first page, FIR. And 163 is...
Yes. This is connected to FIR number?
668 of 2026.
And page 145 you have relied upon. It is connected to FIR number?
140 of 2026.
Yes.
Both are the same date. Now, just please see at page 163 what the investigative requirement is according to them. Page 163, the same FIR. No, the column that he's referring to is the one that is because the same column, recommendation column raises serious questions, but there's his name is not there about you. Yes.
এটাকে সরাও তো। Yes, which page
Now,
you are relying?
page 166, if your lordships come.
Page 166.
Yes, part of this, because the allegation apparently is that a whole bunch of discrepancies are there in the beneficiary numbers, and I had apparently recommended these beneficiaries. Page 166 is the so-called sample cases.
That is part of complaint.
Part of the complaint for FIR 668. FIR 668. It continues to be part of FIR 668.
Yes.
There is, as your lordship can see from these lists.
166, yes.
166. There is absolutely no reference. There is no reference here at all about who has recommended what over here. There is just a contact number in the
No, it
last.
starts page 166, that sample cases.
Yes, because at page 163 bottom, second bullet point, investigative requirement. This is as far as I am concerned, bottom of the page, investigative requirement. The repeated appearance of the name of Sri Abhishek Banerjee in the recommendation column raises serious questions requiring investigation regarding the nature, source, and extent of his involvement. The agency must determine if automated processing credentials from his office influenced or bypassed standard administrative physical screening protocols. Now, the list that is annexed has absolutely nothing to do with me. This is the recommended list. Nothing to do with me. My name is not in the list of people who made any recommendations at all. And this is all annexed by him in his complaint. Now, once again, deliciously vague, no specific allegation, and most importantly, no explanation for the 6-year delay.
Yes, yes.
Then item 5, my lords, in the chart, if I can trouble you again. There are how many complaints on this? How many complaints of elderly? No, no, how many complaints so far? Treatment of elderly people, how many? It's only one. Item 5, my lords, is a complaint once again about a week of rest for Mr. Abhijit Das, after which he comes back with his 23rd June complaint, dealing with an incident of 2023. This is item 5.
Yes. Item 5.
Yes. So this is regarding a initiative by my client of 2023-24, where in his constituency of Diamond Harbour, he had started a Shraddha Aragya initiative. It's financial assistance for elder people. There's not government, it's a private initiative by him. Now, this led to a complaint, and the allegation is that he did not have any financial disclosures or audited financial statements. If at all, this is an income tax issue. If at all, once again, no explanation for the 3-year delay. Money here was collected from the public and donated. Just see page 172, my lords.
This is under Bishnupur police station.
This is Bishnupur police station, yes.
2026.
Yes. 23rd June 26 of Bishnupur police
But the
station.
particulars are not made available in the writ petition.
FIR is not available with us. Complaint is here.
So let us keep this.
But the complaint I'm showing you, because
Complaint is there.
Complaint is there. Complaint is at page 170.
Particulars are available in this petition.
My lords, it's at page 170. In this chart, my lords, in last column gives the page numbers. So complaint is there at 170 onwards, and media reports from 187. Just complaint at 170. And the receiving of the police is there at 170. Our concern is that these complaints will be kept in cold storage, and after every or other date in this court, they will start registering it as FIRs. So page 172. Your Lordship sees core facts requiring verification. So this requires verification, is admission in the complaint. Page 172. So we'll keep the already heavily burdened 172. Core facts requiring verification. So effectively, my lords, each of these complaints, if I may, is to burden an already burdened police service to try and do some fishing to try and figure out if there is a offense made out. So core facts requiring verification, they're given the particulars of the primary launch venue. Total enrolled beneficiaries are 76,000 senior citizens, individual monthly benefit, aggregate annual outflow. Now, reported contributors approximately 16,380. The annual figure of approximately 91.2 crore has been calculated. I'm sorry, I'm in the middle of page 172. Middle of page 172. Just after the table, middle, the annual figure of, Your Lordship, brother?
Yes.
of approximately 91.2 crore has been calculated on the basis of the publicly reported beneficiary count of approximately 76,000 individuals and the publicly reported monthly benefit amount of 1,000 rupees per beneficiary over the 12-month period. Scale of operation and reported funding structure. According to publicly available reports and statements attributed to Shri Abhishek Banerjee, approximately 16,380 volunteers are stated to be contributing funds towards providing a monthly financial benefit of 1,000 to approximately 76,000 beneficiaries within the Diamond Harbour parliamentary constituency. If the reported figures are accurate, the aggregate annual disbursement would be approximately 91.2 crores. The complainant has not been able to identify from publicly available sources any comprehensive donor register, audited financial statements, publicly disclosed contributor database, institutional governance framework, or other comparable records explaining the collection, management, accounting, verification, distribution of the funds reportedly utilized for the initiative. These circumstances warrant independent verification. So it's not even an offense yet. I don't know. Because I don't know, you, the police, will go and try and verify. Independent verification by the investigating agency in accordance with law. And as a consequence of all this, at page 176, my lords, 4 pages on, prayer B, page 176.
So then FIR is registered, but the number of FIR is not available to
Is
you.
it registered? Do we know if it's registered?
So far complaint dated 23rd June 2026 is concerned by
We don't know
one
if-
Abhijit Das.
Yes. This
Case started.
we don't know if an FIR has been registered because it's not been uploaded. We don't know.
Then what is
But
the use of entering into this?
That is why, because if you see prayer B, this is hanging over my head right now. Just see prayer B at the
If
bottom.
that is registered, then you place this documents.
My lords, my problem
Only
is
with
yes.
regard to the cases where FIR is registered and investigation has started, to
Yes.
place those facts on.
The reason why I'm asking this is my prayer K is about future registrations, because that was the identical
that
prayer.
I will not permit.
Just allow me to just try.
Whatever will be registered in future, that will be anticipated and exercise is to be made by the court. Whether that will be an
So
appropriate proceedings or not,
so
that I will not permit.
let me just I'm
No.
sorry, I should have modulated my prayer. I am not saying that your lordships will
That's
restrain.
why I am repeatedly saying
No, I understand.
that
I
please
understand.
restrict your
Yes.
matter
Yes.
to those cases
Yes.
where investigations have been commenced on registration of FIR.
So
not beyond that.
Let me just clarify, because I think I've been misunderstood. Let me clarify. I am not saying restrain the police from registering FIRs. I'm not saying that. I am not saying that. What I am saying is this. We have a set of FIRs all filed in a slew immediately after the declaration of results with great delays. We have a set of complaints also asking for FIR registration. That we have. Concretely, we have. As far as the FIRs, I'm making the initial prayer. As far as the complaints are concerned, I'm making a different prayer. I am saying, just like your lordships have in the past in all those cases where clear political animosity was shown, all they have to do is, where they are acting on those, let them take the leave of the court. If your lordships are satisfied that in fact that FIR needs to be registered, I have nothing to say. That will end the matter. But that leave of the court is something that has been granted to the people who I apprehend are the ones behind this. And I'm in a more peculiar situation because now the chief minister of the state, who is also the home minister, has made public statements specifically that even if there are cases against Abhishek Banerjee pending in the CBI, we'll have that brought to the state. I will prosecute.
Don't make any
It's an
submissions
apprehension.
beyond record. Mr.
It's an apprehension.
My learned
It's
friend
only a-
cannot make statements,
Allow-
my lord, which are
No,
political.
that I
I
will not
don't
permit.
think-
Sorry, you restrict your case to the cases which have been registered and
if I may-
investigations comments.
If I may
What will
restrict
happen
my
tomorrow, whether any
No, no.
proceedings will be initiated or not, that court will not enter into.
So I will just take your lordships through these FIRs and the complaints.
So which
The
you are submitting
eight
that is
which
a
are in the
question
writ
of
petition.
taking leave, that is not considered to be gone into in the present proceedings. Restrict your submission with regard to the proceedings which have commenced, not beyond that.
I'm taking your lordships through to the 8 which are part of the writ petition. which the table you saw at page
8 and
11.
where particulars are available to you.
Yes.
Out of
yes.
8, at least in 4 proceedings, there are no particulars.
Yes.
So anticipating that these are the particulars and based on your submissions, that there is nothing in the complaint, court will not enter into this issue.
So the reason why.
So let us restrict our exercise.
Yeah,
Come to your chart which you have provided.
Yes.
Come to page 12 and 13.
This became an FIR. Yes. So just for
11 and 12. One is 121, FIR number 121.
Yes.
Then FIR number 140. Then FIR number 668.
Yes.
These are the 3 FIRs where
Yes.
particulars are provided.
Yes.
I will grant you leave at best this court can also direct the concerned respondent authorities to provide particulars of those FIRs if FIRs are registered.
Yes.
And you will be granted leave to take steps in accordance with law. But so far the present writ petition is concerned, restrict your submission. So far particulars are made known to this are made known to you.
Yes.
Not
Now,
beyond that.
The complaints which I have placed on record with the petition go from 1 to 8. I am before a constitutional court. It's not a 482. I am before a constitutional court saying, much like in cases where liberty, detention, all those questions arise, that I anticipate coercive steps being taken. The coercive step starts from the registration of the FIR onwards, where I have concrete complaints which have been acknowledged by the police stations. And there seems to be a concert, particularly as far as one complainant clearly, who is the complainant for 7 of them. There clearly is an initiative that is being taken by which the police, without applying their mind, are registering the FIRs and going ahead.
The prayer
So
only
allow
states
me-
about Bhawanipur,
I don't-
Sheliguri, Kalitala, Ashuti and Bishnupur.
I'm a little intrigued by this constant interruption.
Might be, but I cannot travel beyond the prayer.
No, I'm not
There's
asking.
only one thing, my lord. I don't think your lordship needs to be said, informed this. Lord, my learned friend wants an advance ruling kind of a situation in income tax. What happens that your lordships may examine whether offence is made out, prevent the police from going into the investigating
Yes.
part,
To
and I will
register
be able
FIR. Prevent the police from registering FIR.
FIRs, my lord. That's my lord.
That I've said clearly. I'm not asking your lordships to prevent
even-
the police. I've
even
said very
when
clearly.
FIRs are
I don't think
registered-
Mr. Mehta was there when I said it.
No, I was there. I was hearing you. Lord, even if FIRs are there, Lord, you have to show that either no offence is made out or you have to show that there is some statutory bar. Lord, except that, my lord, how my learned friend can
Or
trouble your
delay.
lordship with factual controversies?
So, Mehta, one thing is placed before this court for consideration that into the FIRs, particulars of which are made available to this court, that first of all, it's an complaints not pinpointing the petitioner that he is accused in the case. Only
Correct,
on the base of based on surmise and conjecture, this FIR is made. But this court will not restrain the investigating authority to investigate. But where is the necessity to take the petitioner into custody for
May I,
the
my
sake
lord?
of investigation?
May I,
Let
my lord?
investigations be continued, and I will direct the
Lord,
petitioner
may I,
cooperate
my lord,
with
before
But where is
before
the
your
necessity
lordship,
of
my lord,
We have already complied in the other 2 matters
my lord,
also.
before your lordship, my lord,
And Mr.
my lord,
Mehta, that's
formulate-
by a person who has twice lost election, and he is alleging an incidence and commission of offense of 2020, 2017 to 2025. And this FIR was lodged and complaint was lodged after publication of result on 4th of May 2026.
May I answer your lordship's question, my lord, and thereafter Mr. Raju is appearing for the IO. My lord, first of all, my lord, your lordships are aware that one line FIR is enough, that this is the offence committed, please investigate. So my name is not there in the FIR can never be a ground for quashing. That's my respectful submission. Number 2, my lord, if the offences are committed at a stage where you were in a position not to ensure that FIRs are not registered, then, my lord, you cannot raise an argument that the offence is old and FIR is registered now. Third, I'll assist your lordships with the line of judgments which takes the view that in criminal law, mala fides has no place. Lord, the Supreme Court has went to the extent of saying that it is only your opponents who will bring some criminal acts or your misdeeds before the statutory authorities. So it is no argument saying that because I lost, because there is an election, because there is a new dispensation, then only, my lord, that is enough ground to quash everything. Otherwise, my lord, that can never happen. So long as I am in power, I'll not.
That's why court is contemplating not to pass an order directing restraining the investigating agency from carrying out investigation.
Can I only complete?
Yes, yes.
Lord, second, Lord, if I am apprehending an arrest and if I am an ordinary citizen of India, I am not a special citizen or I am not holding, my lord, any office or I am not a big politician. My lord, what would I be told in a 226 or even a 482 petition? Go and get anticipatory bail. You have a remedy of anticipatory bail. Lord, why I'm putting a question to myself. One individual seek a special treatment that I'll not go to any other court. I will come by a omnibus petition raising several grounds, and your lordships would kindly appreciate each FIR is different FIR, different police station, different facts filed by different complainants. And your lordships are not having, my lord, the advantage or benefit of what are the allegations, what has happened so far. My lord, even if this was to be argued in a 438, not possibly the court would be very, very reluctant at this nascent stage of, my lord, investigation to prevent such an order. And nobody has so far said that we are going to arrest. My lord, these are the parameters, my lord, and we would assist your lordship with all those judgments. Please kindly, my lord, not formulate that proposed, my lord, or a contemplated order. Well, otherwise, my lord, we would be unwittingly, unknowingly, my lord, giving a different treatment to someone who is well known and someone who is just an ordinary citizen. My lord, he is coming not with different FIRs, and I am not saying as a matter of, my lord, just technical objection. My lord, each FIR, as I have said, at the cost of
But against
repetition,
ordinary persons, so many FIRs within such a short period is generally not found.
they are, my lord, registered. They are registered, my lord. It's not something new.
With delay.
Yes, yes.
It depends on the type
All
of.
FIRs are
Yes,
after
yes,
publication
I
of
can give
publication of
instances.
result of assembly election.
My lord, your lordships would like to go by
And
political equations, my lord.
Mr. Mehta, one thing also I am expressing my mind that in one of the matters already this court has granted protection to the petitioner, but at the same time directed the authorities to carry on investigation. And
I
petitioner
am not aware of the facts of that
will
case.
cooperate. If similar order is passed in the present writ petition and directing not to take any coercive steps, provided petitioner cooperates with the investigation, then where is the difficulty?
My lord, I would cite, my lord, one
For the sake
judgment.
of
My learned
investigation.
friend, Mr. Raju is here, my lord. He would cite a direct judgment where 3 judge bench of the Honorable Supreme Court has said that these kind of orders would not be passed. But I'll satisfy your lordships in a quashing petition. And the court has said that you go and ask for anticipatory bail or whatever other remedy you have. This is not a remedy under either 226 or, my lord, 32. This is not a constitutional remedy, my lord. My lord, Mr. Raju is here, my lord.
Yes. Yes.
May I make my first submission is this.
No, my lords,
My
I haven't
first
finished.
submission is-
Mr. Shankaran
I have
has
not
not
completed, my lord.
No, I haven't completed. So allow me to
So let him
complete.
complete and
I
then
just,
I'll-
just
Certainly.
the learned solicitor was just responding, so I didn't want to say anything. He's finished. Just let me respond.
Only one thing, my lord, bear in mind.
Yes.
My lord, mana fides have no place in criminal investigation or criminal jurisdiction.
Give the copy. Give the copy.
That is judgment. PP Sharma judgment citation though. But that is, my lord.
If I may.
1990.
But I'll just, my lord, I'll cite those judgments. I'll also request Mr. Raju to cite the judgment.
If I may just address.
Oh, only a minute, Mr. Gopal Shankar Nayak,
Yes,
if you don't mind.
yes.
Only one thing.
Of course.
But I'll just, my lord, read one paragraph, my lord.
Yes.
And my lord, there are series of judgments on this, my lord. My lord, please have a look at, my lord, the citation would be, and there are many, my lord, I'll assist your lordship. 2008, volume 8, SCC 781.
Paragraph
38, my lords.
paragraph
37, 38. And
37.
other judgments, my lord, will place for your lordship's consideration. This has, my lord, just immediate reference. Your lordship need not, my lord, right now take the book, my lord. I'll read it, my lord, slowly.
And where does this
In fact, my lord, may I read? I'm
Yes.
quoting. In fact, the question of malafide in a case like the present is not at all relevant. If the complaint which is made is correct, an offense has been committed which will have to be established in a court of law, it is of no significance that complainant is a person who is inimical or that he is guilty of malafide. If the ingredients which establishes the commission of the offense or misconduct exist, then the prosecution cannot fail merely because there was an animus of the complainant or the prosecution against the accused. Allegations of malafide may be relevant while judging the correctness of allegations or while examining the evidence, that is the time of trial. But mere fact that the complainant is guilty of malafide would be no ground for quashing the proceedings. Well, there are many judgments, but we'll place it for your lordship's consideration.
Yes, cited in the same paragraph, Tushar Bhai.
Yes. Yes. Manoj, if I may, just to respond to this point first, because I don't want that to detain your lordships for too long. Bhajan Lal, which everybody is familiar with, has been on a cursory search in SCC cited 16,180 times by the courts of this country. Just that flag is on para 102, which is the locus classicus on the point. It has remained undisturbed till date. May I read that first paragraph? In the background of the interpretation of the various relevant provisions of the code under chapter 14 and of the principles of law enunciated by this court in a series of decisions relating to the exercise, give him a copy, relating to the exercise of the extraordinary power under 226. Please mark that, because that is the power we are invoking today. Or the inherent powers under we have extracted and reproduced above. We give the following categories of cases by way of illustration, wherein such power could be exercised either to prevent abuse of the process. Prevent abuse, that's what I'm asking for. Or abuse of the process of any court, or otherwise to secure the ends of justice. Though it may not be possible to lay down any precise, clearly defined, and sufficiently channelized and inflexible guidelines or rigid formulae, and to give an exhaustive list of the myriad kinds of cases wherein such power should be exercised. Without further ado, if I can take you to number 7. Just directly to number 7. All the others are also what I'm relying on, but number 7 on the next page. Where a criminal proceeding is manifestly attended with malafide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. So far from the solicitor's formulation that the law does not say this, the law specifically says this, and it has been followed in umpteen cases, not least of which is the judgment that Mr. Raju drew your attention to of 24th October 2025 of this court in Mr. Suvendu Adhikari's case, where the examples of malicious prosecution are recorded from page 7 onwards.
Just a minute.
Yes, Manoj. I just want to take your lordship to the final judgment, page 10. Page 10, internal page 10 of that. Yes. About 5 lines down, 2 lines down, in a similar manner, second line.
Yes.
If I may read that, because they've given the narrative of all the previous FIRs and complaints. In a similar manner, several other fictitious and frivolous cases have been registered against the petitioner at the behest of members of the ruling dispensation in order to wreak vengeance against the petitioner for changing his political allegiance. A plain reading of all the FIRs registered against the petitioner demonstrate the malicious intention of the de facto complainants who are hand in glove with the ruling dispensation and state machinery. All the FIRs have been carefully and meticulously curated using legal terminologies to make sure that a cognizable offense is made out so that there is no room left for the petitioner to defend himself. At least in our case, they have not been so careful. Thus, in the present circumstances, this honorable court owes a duty to look into other attending circumstances emerging from the case records and try to read in between lines to find out the reality behind registration of such FIRs against the petitioner. The proposition that malicious prosecution is different from a malafide in law, as has been reiterated by several judgments passed by the Honorable Supreme Court, starting from Bhajan Lal. The courts have time and again held that the high courts can exercise the extraordinary power under Article 226 of the Constitution and or their inherent powers under 482 of the IPC to quash FIRs that were initiated with malicious intent, and reliance is placed on Bajnath Jha, Vineet Kumar, Haji Iqbal, and Mast Rehana Begum. Those are just illustrative, my lords. Now, if for a moment I have shown your lordships illustratively in the first 5 cases from the table about the complaints and the FIRs that were registered. I wanted to show your lordship from the same table, item 8, to make real my apprehension about what has been taking place. Item 8. Your lordships have that? It should be page 4, I think, of the table.
1st of July 2026.
Absolutely. I'm grateful. Now the complaint, I'm just showing your lordship this. Complaint is 1st July 26. This writ petition is filed by us on 2nd July 26. Immediately thereafter, this was the advance service. The writ petition. After service on them. 4th July 2026, FIR is registered. Now this kind of case, if we have to accept the proposition being put by my friends that I can't seek your lordship's extraordinary power and protection in this kind of a case, then where am I, my lords? Because I have complaints which they have filed against me. Same people file again and again. And these are all meant to take away my liberty. Now I stand here as a citizen. Forget the other hats I wear. I stand here as a citizen and say, how long will this go on? Because I'm showing your lordships the complaint. They take a technical objection that the FIR has not been registered by me. Once your lordships pass an order, they will register an FIR. Then we'll go into paperwork and come before your lordships. Time will be taken because different councils have to appear. And then finally, after a month, where maybe God knows some steps are taken against me. That's my real apprehension. This is a real example. This is a very real example where I have the FIR, but that FIR is only, do I have the copy? It's in the supplementary, which I'm not relying on. I make it clear I'm not relying on. But this is a real apprehension. Now for a minute, I want to show those orders. I want to show your lordships the orders which were passed, not in one case, my lords, in 4 different cases, all for the political purpose, all from July 2021 onwards till December 2021. We have put it together in one place for your lordship's convenience. Copy. These are orders of the court. Where is it here?
Thank you.
Thank you. Just give me this comparison. Give it. Your lordships have this. The first one, my lord. I in fact want to go chronologically. So let me take you to item number. Dhyanesh Guha is which one? 5. Item number 5. I'm going chronologically because I want your lordship to see how this moved. Hey, you don't have page numbers in this. How will I show it to the court?
We have paper table. This one.
This is dated 8th July 2021, my lord. Lordships have that table item 5?
Yes, serial number.
Dhyanesh Narayan Guha.
Yes.
That's the first one, 8th July 21 order. This, yeah. In order, we should have put this first, but this is, your lordship will see the 3rd column. 13 FIRs are there, all together in a single writ under 226. 3rd column, this is the order of 8th July 2021. Now, I am afraid we have
page right from the back.
It starts from page.
I'm sorry, we have not put internal page numbers. So just the last, if you start from the last page, my lords, that order is of 8 pages. The first page of that is 8th July 2021. My friend had appeared there.
Which? Sir, I do not have the copies of what you're referring to, my lords. I don't have copies.
Do you have
I've
soft copies?
given it. I've given it.
No, I've just been handed over with a hard copy.
Yes.
Do you have soft copies?
Neither of them.
But if he's relying on documents, we should be given time. It
These are not
can't be that
documents.
the-
I'm not relying on documents. These are orders of.
Post ordered and
sorry.
it has been given to your
You
junior.
have given me the
It has been given
document.
just now, my lord.
Additional
How-
advocate. general.
Just been handed over.
Yes.
Yes,
But
I'm-
learned
Copy then.
Advocate
You
General
can't
has
ask
made
us to send it
detailed
for the document. I
submissions.
can understand if a judgment.
Interim protection to the, this is page 1 of that. Interim protection to the writ petitioner against coercive action by the state is sought at this stage. The fact that appear from pleadings are that between 14th May 21 and 18th June 21, the following
We are
13
reading
FI.
from first page of that judgment order dated 8 July 2021. Yes. Interim,
Yes.
yes.
The facts that appear from the pleadings are that between 14th May 21, your lordship will recall 2nd May 21 is when the results were declared in that year. Between 14th May 21 and 18th June 21, the following 13 FIRs have been registered against a petitioner based on complaints received from 13 different persons. The table is there, my lords, with the various offences. Some of them are fairly
But the
serious.
particulars of FIR were available before the court,
That's true. They were available.
not
They
in
were available.
anticipation.
No, so in this one, yes, FIRs were available. All but one of the FIRs led to incidents that have occurred after 2nd May 21. The other FIRs of incidents that took place in year 2020. The petitioners obtained bail in at least 4 cases on 15 June 21. There are warrants of arrest issued against petitioner in some FIRs after bail was obtained in other cases. Learned Counsel for Petitioner submits that the date 2nd May 21 assumes a lot of significance since the assembly elections in the state were concluded on that day when results were declared. I am saying 4th May 2026.
Yes.
The writ petitioner submits that complaints were filed.
Both dates are in the month of May.
Beg your pardon?
Both dates
Both
are
dates
in
are in the month of May. 2 days
May,
apart.
one in 21, another in 20.
That's why I said it's mirrored. It's mirrored. So assumes a lot of significance since the assembly elections in the state were concluded on that day when results were declared. The writ petitioner submits that complaints were filed and 13 FIRs were registered post 2nd May only because the petitioner had moved from one political party to another. The complaints are a result of the vendetta of the complainants who belong to a rival party. It is stated that the petitioner has no faith in the investigating agency any further given the number of FIRs registered in single police station, etc. Then the whole bunch of arguments, my lords, which is taken by both sides. And I will just take your lordships to the conclusion from page 5 bottom.
In the instant case, it is seen.
Absolutely last paragraph. Last paragraph. However, having considered all the decisions cited by the learned Advocate General, this court sees a very rare and exceptional instance where 13 complaints have been filed immediately after the declaration of results in the recent assembly elections. The uncanny timing, I'm sorry, I'm top of page 6.
Yes.
The uncanny timing of the FIRs cannot be lightly brushed aside and are enough for this court to consider passing interim order. One also cannot brush aside the argument that the change of political color by the petitioner is the ulterior reason behind the number of complaints being filed against the petitioner, albeit by different persons. Then the transfer issue, which is not germane here, and last paragraph on the next page, my lords. Next page, page 7, middle paragraph, second paragraph. However, this court definitely sees extraordinary circumstances and 13 successive complaints having been filed before one police station against the writ petitioner in a span of 30 days. Malafide FIRs would normally attract the jurisdiction of the court under the CRPC, but 13 successive FIRs would bring into focus likely violation of Article 21 of the Constitution. In the Bimal Gurung case, it has been held that transfer of investigation can be made in cases where there is violation of fundamental rights. As already stated above, interference is called for in view of present immediate threat of violation of Article 21. That's what I'm adopting. The cases which call for interference are not restricted to involvement of high officials or accusation against other investigators or for bias. In such a situation, this court's power under 226 must and should be exercised to come to the aid of a citizen whose personal liberty is at threat. For inter alia reasons indicated above, this court is inclined to direct the so-and-so police station not to arrest the writ petitioner without leave of this court. Particulars of all other FIRs against the petitioner shall be furnished to the petitioner by the state forthwith. Petitioner unconditionally undertakes before this court to cooperate in the investigations in all cases. The state shall file, etc., etc. And now, my lords, I wanted to show your lordships the interim order which was passed on 8th December 2022. There are other orders. but I just want to show your lordships the last of the interim orders, which is 8th December 2022, which is serial number 2 at the table at the top, at the beginning. Is it this one? No, just check. I don't want to be wrong.
WPA 25522 2022.
That is 8. No. It's 25522. Yes. 25522. Where's the order in that? In this? Where will I find it?
It's at page 47.
It will be approximately page 47 from what I understand, Manoj.
Just
You have it?
8 December 2022.
Yes, Manoj. I'm grateful. That's the one. 8 December 2022. And from second page onwards of that, actually bottom of that page, the writ petitioner is the leader of the opposition in the state, page 1.
Second page.
First page, I'm sorry, first page. I should have. Writ petitioner is leader of the opposition in the state. He's aggrieved by the state lodging 17 FIRs against him. Sum and substance of the argument of so-and-so appearing for petitioner that FIRs which have now reached 26 in number are an attempt to prevent the writ petitioner from performing any functions as a people's representative. The said FIRs have been registered motivatedly at the instance of the ruling dispensation, and the details are given, my lords, of all these FIRs, of 13 of them at that point. Please note, only 13 details were given at that point. The court is also required, page 4, court is also required to consider as to whether, since after a restraint order was passed on the state against coercive measures on the writ petitioner on 6 September 21 and so-and-so writ petition, a novel method has been adopted by the ruling dispensation to choke the writ petitioner in FIRs and notices under 41A, thereby frustrating the effect of the said order passed by this court in the said writ petition. Give me the dates of the other two orders. We got by the said order dated 6 September 21 passed on the aforesaid writ petition, a series of 6 FIRs filed against the petitioner were considered by this court. This court had found that there was a scheme or design by the ruling dispensation in the state to somehow deprive the writ petitioner of his liberty. Some of the FIRs were stayed, and the writ petitioner was asked to cooperate with the investigation in other FIRs of so-and-so police stations. Thereafter, about 17 FIRs have come to be registered against the writ petitioner. The order is extracted, my lords. I'm not reading that. And after that, after the extract, page 6, after the extract, it is argued that most of the aforesaid FIRs are in respect of small, flimsy acts alleged against the writ petitioner. There are threats and public speeches stated to have been made by the writ petitioner. Some of such speeches are stated to have hurt the sentiments of a section of citizens. These are threats and intimidation alleged to have been made by writ petitioner while canvassing for votes. In fact, some of the complaints based on which FIRs have been registered have been described as fill-in-the-blank FIRs. The name of complainant, age, father's name have been left blank to be filled at random. Such blank complaints appear to have been handed out casually to persons owing allegiance to the ruling dispensation. Such persons appear to have left such complaints at police stations or filling in blanks at the concerned police appear to have mechanically, overzealously, and in furtherance of the dictates of some quarters, registered FIRs in a premeditated manner. The actual intended consequence of FIRs is that for 26 days in a month, the writ petitioner would be confined in police stations to respond to notices under 41A and be forced to obtain his public duties. It may be necessary to refer the submissions of the learned counsel for the writ petitioner that his client had contested in the last assembly elections against the present head of the ruling dispensation and won. The personal vendetta of some persons owing allegiance to the said person against the writ petition therefore cannot be ruled out. The reasons behind dragging one single individual and his family members in such volume of complaints and FIRs are argued to be irrational and unexplained and motivated. If I can skip down, my lords, at page 8, the court says, page 8, bottom of page 8, however, that by itself cannot give a carte blanche to the state police to indiscriminately register FIRs against the writ petitioner and mechanically or motivatedly so. This court refers to observations made in paras of the order dated 6 September 21, the earlier order, which is referred to above. The allegations of counsel for writ petitioner that each of the FIRs registered against the writ petitioner post the order dated 6 September were an attempt to frustrate the protection order granted to the writ petitioner cannot be brushed aside. There is substance in such argument. And about 2 paragraphs down. However, in the peculiar facts and circumstances of the instant case, the fact that the writ petitioner is an elected representative of the people holding the post of leader of the opposition, if I may pause, my client is a member of parliament and he is the national general secretary of this party. The court's mind is not free from doubt that the state police machinery, either on its own or under the influence of persons in the ruling dispensation, is out to completely stall the public life and personal liberty of the writ petitioner. There appears to be a calculated design to deprive the liberty of the petitioner. As stated, already stated here and above, there appears to be an attempt to bypass interim protection granted to the writ petitioner in the order dated 6 September 22 that has been that's 21 that has been upheld by the Honorable Supreme Court. In these circumstances, and this is the order that I wish to request from your lordships today. In these circumstances, this court is of the view that each and every one FIRs referred to in the writ petition shall remain stayed. The state police shall not register any more FIRs against the petitioner without the leave of this court. With the leave, of course, without the leave of this court. The other prayers for transfer of investigation, etc., shall be considered after affidavits are received from the respondents. Let affidavit in opposition be filed, etc. This eventually culminated in the quashing judgment which your lordship saw, 9.2, 9.3, Vajan Lal, etc. So we are in this stage now. We are in the October 21 or the July 21 stage where a slew of FIRs have been filed. Further FIRs are on their way. One I have been able to illustrate was immediately after filing of the writ petition and after the complaint had come, they went and registered an FIR. There are others. They're in the supplementary.
The order was passed, post order passed by the Supreme Court.
Yes.
Got to the first order passed by the
correct. The first order was mere dismissal.
Granting protection.
Correct. So the first order was a grant of protection. That also provided
That
for
was an SLP was filed. That was not interfered.
It was not interfered.
Subsequently, this order was passed in another writ petition.
Yes, with a different set of FIRs. So in the same situation that we are in, this is the order that has been passed by the court, because in our case as well, your lordships have passed the protection orders in 2 other cases. And 21st May 2026, both orders are 21st May. Okay.
Yes.
21st May 26. After which, there are more FIRs that are coming through, which impels us to come to your lordships on 2nd July and file a writ petition. Listing at that point what we know, which are 8. That is expanded now to 11. By the next date, I don't know where it will go. Which is why, my lords, I think it is critical that your lordships may kindly stay these FIRs and the leave may be taken of this court for any further FIRs, because that is an order which eventually culminated in a quashing. Now, what was the reason for me to take your lordships through the allegations and the complaints? It was to show your lordships how scandalously casual they are. Not one offense is made out among all of them. And I'm sure they could have made up. It's obvious that they didn't have any material and they decided quickly, now we are coming into power after the elections, so let us get this together. And how ham-handed is it that you have the same person who has lost an election? I'm very grateful, my lords. Yes, I'm concluded my arguments on that. I just seek this same order. I'm very grateful.
Yes, Mr. Raju.
Yes, my lords. My first submission is this, my lords. In cases where he is not an accused, he can't file a quashing petition. I'm relying on a judgment of the Supreme Court in Hukamchand Garg, my lords. That is, my lord, 2022 SCC Online Supreme Court 2165. If he's not an accused, he can't file a quashing petition.
Yes, what is the proposition?
That if you're not named as an accused, you can't file a quashing petition. So some of the FIRs is not named as an accused. Para 2 of this judgment, my lords. If my learned friend, Mr. Bilwadul, has handed over a copy, my lords.
Yes, I've handed to it.
Kindly have a look at Para 2, my lords. It is not in May I read, my lords? It is not in dispute, para 2, that petitioners have not been named as accused in the said crime. My lords have got it, but that is police station.
Yes, paragraph 2.
Now kindly come to, my lords, para 3. In other words, the petitioners not being named as accused in the said crime or the case now registered with CBI on the basis of the said crime cannot be permitted to ask for quashing of the proceedings concerning some of the persons accused. Now, my lords, 5. It will be open to the petitioner to take recourse to appropriate remedy as and when they are named by the investigating agency in the connection with the said offence now under investigation by CBI. Therefore, my lord, the petition is disposed of. So if you are not named in the FIR, you can't move a petition for quashing. If at all you're named subsequently, you can move. Today, the petition is premature. That petition which makes a prayer cannot be. Secondly, my lords, kindly look at the prayer clause, my lords. There, my lord.
Just a minute. Yes.
The prayer clause, as far as C is concerned, Siliguri Cyber Police Station case, there is no FIR. FIR has not been registered. I am told
Yes.
that as far as that said FIR, so-called, is only a diary and they have not done anything, it's not even registered as an FIR. There were prayer for quashing of something which is not an FIR is not maintainable. There's nothing, there's no offense registered. That's the second point, my lords. That's only a diary entry, my lords.
No, court is considering its exercise so far the particulars of FIR, where FIR is registered.
Very well, man. I am obliged.
And I have expressed my mind.
Very well, my lord. Now the next submission is. Therefore, there is no FIR in Siliguri. That is my case, mother. That is para. Therefore, that prayer itself, therefore, my lords is not considering prayer C, I take it, my lords. Which is, now the next submission is based on a judgment of the Supreme Court in P.P. Sharma's case, that if you allege malafide, you must name the person against whom you allege malafide by name. Kindly have a look at para 55 of State of P.P. Sharma's case, 1992, 1 supplementary cases. Page. State of Bihar versus P.P. Sharma matters. Para 55.
Just a minute.
Now, my lords, look at the cause title. Nobody is by name. 1992 supplementary 1 SCC page 222.
Paragraph?
Paragraph 55. Person against whom, now 55.
Yes, paragraph 55, place it.
Yes. I'll come back to the other paragraphs, but 55 I'm reading first, my lords. Where is the marked portion?
Yes, Mr. Raju, place it, paragraph 55.
It is settled law that the person against whom malafide or bias was imputed should be impleted EO nominee as a party respondent. By name, he should be made a party in the proceeding and given an opportunity to meet those allegations. In his or her absence, no inquiry into those allegations could be made. Otherwise, it would be violative of principle of natural justice as it amounts to condemning a person without an opportunity. Admittedly, both R.K. Singh and G.N. Sharma were not implicated on this.
Complaints are made party.
They're not made party. They have to be heard before.
Complaints are made party and they are served.
No, they are not by name. They are not by name.
Correspondence 13 to 16.
Only
I
the
don't think you've
complainants
seen
have been made.
They are made party.
No, kindly have a look at the page.
Complainant are made
Kindly look
party
at the page
against
number one,
whom
my lord.
this is malafide is made out.
No, my lord. Kindly have a look at the cause title, my lord.
Yes.
Huh? They are not here. They have not been heard.
They are
Nothing.
made by name. Come to page 4 of the writ petition.
Yes,
That is
my lord.
that is cause title, part of cause title.
Yes, my lord. Cause title that
And
I
I
am
have
having.
satisfied myself with regard to service which was effected upon them.
They
prior
are
to
only
making
the
this writ petition.
complainants. They are not the. Kindly have a look at. But only 14, 15, and 16 are the complainants. They are not the persons against whom allegations are made. The allegations are made. They are the informants. They are not the persons against whom malafides are made.
But the case of malafide is concerned, that has been made out with regard, which is restricted to the complaint made by the alleged de facto complainant.
But the allegations of malafide are not with respect to the complainant. They have only given a complaint. The malafides are with the police who registered the offense. Those
It is
police officers, those
submitted that the complainants made malafide complaints. That is the case.
No, my lord. They say political, my lord. His entire contention is politically motivated, political malafide. That is his case. It's not that the complainants are the malafide. The complainant. His case is politically influential people. The police have malafide registered the FIR. That's his case. I can understand that the complainant who doesn't have influence is not politically concerned. There is no case. Now kindly look at the averments, whether they have averments.
According to whom, Mr. Raju, who are to be made parties?
The person against whom you allege malafides.
Who are they? According to you? So
according to me, let us look at this petition and I'll demonstrate against whom he has made those allegations. It is not against the informants. Now kindly have a look, my lords. Para 3. Petitioner is filing. My lords are having para 3 of the petition. Petitioner is filing instant writ petition being agreed by arbitrary and illegal action taken by respondents 1 to 13, not 14, 15, the others who have been named. So arbitrary action, malafide action is attributable to 1 to 13 who are not named, culminating.
1 to 13, where? In which reference to which document you are saying 1 to 13?
Cause title of the petition.
Yes.
Is filing. Now, 1 to 13, my lords may kindly have a look. Filing the instant writ petition being agreed by arbitrary and illegal actions undertaken by respondents 1 to 13. Therefore, illegal actions, malafide actions is all attributable to 1 to 13. And if my lords goes one paragraph above, respondent numbers 14 to 16 are necessary for proper parties for complete and effective final education because they are the informants. Informants are named, they have to be named. But the persons against whom malafides are there, persons against whom arbitrary action has been alleged are not made parties.
Yes.
Now, my lords may kindly have a look. Facts are stated.
Yes, yes.
Now, kindly come to G. Petitioner states that the aforesaid conduct of the leaders of representative BJP clearly established there exists a premeditated, predetermined intention on the part of BJP and leaders, both the national and state level, that the event the BJP forming the government in the state of West Bengal, petitioner would be subjected to retaliatory and coercive measures. This is vague governments. No, which party, which functionary of BJP, nothing. Not made a party. The allegations of malafide are against this person, not against 14, 15, and 16. Then the next paragraph. Last paragraph, para G, a compilation of statements made by leaders and representatives of the BJP during election period and prior to it published in media reports, which demonstrates a consistent pattern of hostile and vindictive statements against the petitioner, including but not limited to issuing threats and putting the petitioner behind bars, has been annexed. That these are the persons against whom malafides are alleged.
Yes, so that is your submission with regard to this judgment of 1992 supplement 1. I get your point.
Yes.
What is your next point?
Yes, madam.
Yes.
Now, my kindly have a look. The next point is one judgment which has been relied upon by the learned Solicitor General that if an offence is made out, Malafites is insignificant. There are several judgments. The one paragraph which which the learned Solicitor General read, the extract refers to large number of judgments at the end of that paragraph. Even 92, this judgment, this very judgment, my lord, that is Monica Kumar, which the learned solicitor read, my lords.
A copy of this judgment, 2008 SCC.
Yes, yes.
Relied upon by Mr. Mehta.
Yes. Para 38.
Yes, just a minute.
37. Now look at the judgments on which reliance has been placed. 37 and 38. 37, end of 37, my lords.
Just a minute.
I am reading 37 and then I'll refer to JSC Sultana.
Yes, yes. Place it, Mr. Raju. 37, 38.
In fact, the question of Malafites in a case like the present is not at all relevant. If the complaint which is made is correct, the offense has been committed, which will have to be established in a court of law. It is of no significance the complainant is a person who is inimical or that is guilty of Malafites. If the ingredients which establish the commission of an offense or misconduct exist, then prosecution cannot fail merely because there was an animus of the complainant or the prosecution against the accused. Allegations of Malafites may be relevant while judging the correctness of the allegations or while examining the evidence, but mere quashing of proceedings, but would be no ground for quashing of proceedings. So when there are whether to test whether the allegations are correct or not, at that stage Malafites may be required, but Malafites by itself cannot be a ground for quashing. Now look at the judgments which have been referred to. State of Maharashtra versus Ishwar Piraji, Zandu Pharmaceuticals, State of Bihar versus JSC Saldana, 3 judges, and State of Orissa versus Saroj Kumar Sahu. There may be exceptions, but we are not concerned with such a case. Therefore, the Malafites are of no significance if the offense is made out. So, therefore, you can't put the cart before the horse and say Malafite, therefore quash it. If an offense is made out, that's it. He has to be tried irrespective of Malafites. Supposing a murder has taken place, and he says there are Malafites of the complainant. There was some dispute with the complainant, therefore quash the FIR. That can't be a ground. You have to see whether the offense is made out or not. If the offense is not made out, Malafites would be an additional ground, but Malafites cannot be the sole ground and the only ground for quashing. This is my submission, my lord. May I take my lords to the other judgment?
Please come to page paragraph 38.
38. This court in its latest decision has held that where investigation is completed, charge sheet has been filed and charges are framed, High Court should not only embark upon an inquiry over reliability of the offences to sustain the allegation made in the complaint, which is the function of the trial court. So when charge sheet is filed, whether the allegations are correct or not, can't be gone.
This observation was made as in paragraph 37 in the context of filing of charge sheet, and when it is stated that this court in the latest decision has held that where investigation was completed, charge sheet had been filed and the charges are framed, the High Court should not ordinarily embark upon an inquiry as to the reliability of offences to sustain the allegation made in the complaint. In this context, paragraph 37 has to be read.
No, I'll point out one thing.
So we are not at this stage today.
May I only point out?
It is not also leaning to pass an order directing not to investigate. Let the investigation be carried out. And I will ensure that the petitioner will cooperate with the investigation. But why coercive steps at this stage?
My lords, I'm not. I'll answer that question also.
So therefore,
let me answer. Let me answer.
By the Supreme Court in paragraph 37 of Monica Kumar Supra has to be read in the context of paragraph 38.
Now, even where the investigation is pending, there are
and try to appreciate the facts. This court is taking these matters. Previously, similar matters came before this court at the instance of same petitioner, where this court had to grant protection. Now, thereafter, spate of complaints. Now, if these complaints are, it may so happen that these complaints are there are certain contents which are required to be investigated upon. But I am asking you at this stage, when court is considering balance of convenience and inconvenience in passing interim protection, that what is the purpose which is to be served by taking the petitioner into custody?
I'm not saying taking the petitioner into custody is
Yes,
not.
yes. Here,
I'll address that. I'll address each one of those points.
Let
I'll
the
address
investigation be
each one of
carried
those
out.
points.
Carried out today. This court is not going to pass an order quashing the proceeding which has been initiated, or court will not pass an order that that no proceedings would be initiated by registering FIR without leave of the court. But in the present case, not to take any coercive steps, since it is to be directed that petitioner will cooperate with the investigation, provided petitioner cooperates with the investigation.
May I now answer my lord's queries?
Yes.
Number one, and not only an FIR, but even a charge sheet can be quashed, my lords, by this honorable court in exercise of powers under 226.
So that will be
Therefore,
considered a time of
Malafites, whether-
on exchange of affidavits. Today, court is not entering into this merit of the issue
But the
for the
petition
purpose of
itself is not maintainable. Petition itself is not maintainable. The persons against whom Malafites are alleged are not made parties. This is number one, my lords. Number two, my lords, this is a petition for quashing, not a petition for anticipatory bail. If a relief of no coercive action or not to arrest, nor to grant interim anticipatory bail can only be granted under 438 and it cannot, 482 proceedings cannot be used to get an order which is akin to an anticipatory bail. At the direct judgment of the Supreme Court on this point, my lords may kindly have a look. His remedy is not a petition under 226. His remedy is a petition under 438. New is 482. What is the new BNSS? Huh? This is a new provision. Now, kindly have a look at 2002 2 SCC page 210, my lords. Again, a three-judge bench of the Honorable Supreme Court. Kindly have a look at paragraph 57. You can't pass an order of anticipatory bail or not to arrest in a quashing petition. The proper remedy is a 438 petition, my lords. Kindly have a look at para 57 of this judgment.
Yes, yes, there are line of judgments, including Niharika properties, if you Niharika infrastructure, where paragraph 33.16, if you read, you will find that yes, when the facts are hazy, it is known to us that when the facts are hazy, and it is that no exercise should be carried out by the High Court while exercising this jurisdiction under Article 226, and when materials are not before this court. But at the same time, court needs to consider the observations made in Haji Iqbal.
Kindly have a look. I point out Haji Iqbal also. Why? Kindly have a look at para 57 of this judgment, my lords. I'll place para 57, my lords.
Paragraph
57.
Just a minute. Just
in this case, facts are similar.
Wait,
Earlier,
wait.
it was unclear.
Wait. Yes, paragraph 57.
Yes. Similar facts. Earlier, he was granted. Now look at this. It is no doubt true that this court earlier on 2 occasions in writ petition number so-and-so and writ petition number so-and-so had granted the relief that in event of the arrest, the petitioner in connection with any criminal case in his capacity of managing director or director of a group of companies, the arresting officer shall release him on bail and is executing bond to the satisfaction of the arresting officer. This order obviously tantamount to an order invoking provisions of section 438 of the Criminal Procedure Code. The court adopted the aforesaid procedure to find out a solution in the peculiar situation, being of the opinion that even though the accused is able to get orders from bail from different courts where the cases are pending, but in view of a large number of cases against the accused throughout the country, it is physically not possible to release the accused from custody. I'm sorry, just a minute. Custody. If an accused is facing a charge under 406, 409, 420, so is ordinarily not entitled to invoke the provisions of 438 of Criminal Procedure Code, unless it established that criminal accusation is not bona fide one. It is difficult to conceive that an accused who is involved in thousands of cases in different parts of the country by cheating millions of countrymen can be given benefit of privilege of anticipatory bail as a matter of routine, as was done in the two cases on the basis of which the present batch of cases have been filed. In the manner in which the white-collar crimes are committed and the extent of which has pervaded the society at large, we are of the considered opinion that two cases decided by the earlier would not be a universal opinion, cannot be used as precedent for revealing the privileged nature of an anticipatory bail. Then my lords may go further. The last 4 lines of para 57, where the court would not be justified in direct release of such an accused under a blanket order like the one which has been
Where from you're reading page 238?
last four lines.
Last four lines of paragraph 57.
Yes, my lord. I am obliged.
Just a minute. While it starts with the word while.
No, but placentum G. But the court would not be justified.
Yes, yes.
I read from that. While therefore we agree with the submissions of the counsel for accused petitioner that an accused could maintain a petition under Article 32, but the court would not be justified in directing release of the accused under a blanket order like the one which has been relied upon by the counsel of the accused person in such a course of action would be to perpetuate gross injustice. Now, my lords, kindly have a look at para 58. We are therefore unable to agree with the method adopted by this court in writ petition so and so, since in our opinion...
Now, Mr. Raju, what was the order passed by the trial court, which was challenged before the Supreme Court?
Now kindly have a look at the...
From which paragraph court will find it?
Para 58. It was a direct petition of 32, my lord. Therefore, there was no trial court involved.
Oh, it is a petition under
32. 32. Now kindly have a look at last few lines of para 58, placentum B onwards. I'll read para 58. May I read para 58?
Paragraph 58, yes, yes.
We are therefore unable to agree with the method adopted by this court in so and so. Earlier orders were distinguished. Similar type of orders on which my learned friend is relying. Since in our opinion, to adopt the method would be giving premium to the accused person. The right of the accused to a speedy trial is now recognized, right, and even it has been extended so and so. Now come to the placentum B, but no contrary proposal came till conclusion of hearing of these matters. While therefore we are not granting any relief to the accused persons on reasons already indicated, we would commend upon the central government to evolve certain formula or procedure so that the accused will not complain of undue harassment on account of protection of the case. So that's a different thing, my lords. Then come to para 63.
That is a different thing.
Yes, para 63, my lords. No, 63 is also.
63. Yes.
To be concluded by contextual facts, a petition under 32 is maintained, but the petitioner is not entitled to any relief by reason of insufficient available materials on record as regards the issue of infraction of Article 21. So he has to produce the material. He has not produced material which show. This was a case of speedy trial, my lords. Writ petition fails and they're dismissed. Therefore, and Niarika, as my lords know, therefore, if he wants a relief, that he should not be arrested. If he wants a relief, that there should be no cause of action. If he wants a relief of anticipatory bail, the proper remedy will be 438, and he cannot supersede that remedy or ignore that remedy and come directly under 482. Now kindly have a look at Sushila Agrawal, my lord, 2025 SCC page 1.
Now please come to paragraph 1 of this judgment, which you have cited. 2002 to SCC 210.
Yes, my lord.
Let us consider the facts, Mr. Raju.
Yes, my lord.
Come to paragraph 1. This batch of writ petitions under Article 32 of the Constitution by reason of supposed infraction of Article 21 were moved before this court for the grant of an order of bail.
In the nature as prescribed under 438.
For the grant of order for bail in a nature as prescribed under section 438 CRPC.
Same as in our case. Kindly look at what has been prayed for.
To crystallize the issue as passed earlier ought to be noticed at this juncture. The first of the two orders read as below. That is not the issue before me.
That's the issue, Malad. That's exactly the issue. Kindly look at his prayers, Malad. Kindly now look at
No,
his.
court has passed an order granting interim protection. There are thereafter spate of complaints which are transformed into FIR. Now, whether at this stage court is considering balance of convenience and inconvenience, whether and to find out whether petitioner is entitled to get interim protection during continuation of investigation.
When my lord says no coercive
So
action,
therefore,
it is.
the ratio of the judgment has to be considered in the context of the facts of that particular
I'm
case.
obliged. I'm not running away from the same, my lord. My lords may kindly say that when a no coercive action order is passed, it is akin to granting bail or anticipatory bail without any conditions. And no coercive action means I can't arrest.
Mr. Raju, how this court can brush aside the previous facts and the order passed by this court in similar situation in favor of the petitioner?
That is this case. Now, let me read para 1 further.
Already petitioner is enjoying protection of this from this court. Enjoying protection in terms of the order passed by this court.
Madam, may I say, madam, those facts are different. These facts are different. If he commits, supposing tomorrow he commits a murder,
But
he'll
I
say,
do not find so that there is a different type of complaint.
a different type of complaint. Yes, but the complaints are all
I don't
different.
find anything that is this complaint. This complaint is the significance of complaint requiring petitioner requiring custodial interrogation so far petitioner is concerned.
That I will demonstrate if it is a petition, my lords, for anticipatory bail. The relevant consideration whether custodial interrogation is required or not is relevant for the purpose of 438. For the purpose of 482 and for the purpose of 226 in a quashing petition, all that I have to demonstrate is that the offense is made out. I am not required to make out a case that custodial interrogation is required. Therefore, my case is this is a bail petition in disguise. Therefore, I have to make out a case that is custody is required or not. If it was not a bail petition in disguise, I would not be required to answer this question. I would be required to answer a question that show me whether an offense is made out or not. That is the test for a 482 petition or a 226 petition of quashing. The test is that whether you want a custodial interrogation is a subsequent event. He must make out a case that there is no prima facie case. He must make out a case that no offense is made out. He cannot make out a case that custodial interrogation is required or not required in a quashing petition. That is insignificant, that is irrelevant, that is not germane to a petition under 482 or 226 for quashing. That's precisely the reason why I'm saying it is a camouflage petition of 438. My lords, may just take me for a minute.
Yes, Mr. Raju, anything more?
I have to some. My lords, may just
Yes,
excuse
yes, yes.
He has not demonstrated, my lord, that prima facie case is made out or not. Huh? Now, there is no apprehension also pleaded. Forget apprehension, my lord. Where is this case that no offense is made out? His only case is it is filed belatedly after 4 years or 5 years. That can't be a ground for quashing. That can't be a ground for quashing. Unless, my lord, the delay is gross. So a person registers FIR. Why it is not registered within 5 years or 2 years is no ground for quashing. The ground for quashing is that no offense is made out. Delay in reporting.
Yes.
Maybe because he is influential, the police were not in a position to take an FIR against him. So influential persons, police generally do not register FIRs. Therefore, that is not an inquiry to be made at a stage of quashing. Therefore, the thrust of the matter is quashing and not bail. Now, my lords, I may also be. This is that the limitation is no bar. My lord, kindly have a look at. Therefore, delay. My lord, kindly have a look at 468 of this CRPC. My lords. This is not an offense which attracts a bar of limitation.
Just a minute.
Which is a corresponding section in BNSS. the legislature
Just a minute, Mr.
the new provision is 514, Manoj. The old is 468.
Yes, yes, what you are submitting? Yes, tell me.
Submission is
Yes, that judgment is over, and now what is your next point? What you are relying upon?
delay cannot be a ground for quashing unless it is barred by limitation under 468. The nature of the offense is such that is covered by 468 and the cognizance is barred because of delay. This is not a case where the offenses are barred under 468 because only those offenses. Kindly have a look at 468, Manoj.
Sorry.
So if the offenses are punishable with 3 years or more, there is no limitation.
Mr. Raju, how long you will take? Because our recess starts from 1:15. How long you will take?
My main submission will be after we file an affidavit and all that, Manoj. But my main submission is that it's not maintainable. How much are the other points left? I've done with most of my points, Manoj.
Yes.
The only thing I have to show from the FIR that it makes a cognizable case. If it makes a cognizable case, it can't be quashed. If it can't be quashed, prima facie it can't be quashed. There is no question of interim relief. So if it's not entitled to the main relief, there is a question of granting him any interim relief. That's going to be my next submission. I have to take my loss through all the FIRs and show that offence is
So
made
that's why
out.
I'm asking
And
how long you will take, because I have to manage my time also. So that's why I'm asking you that how long you will take, because our
now
recess will
remains
start
is
from
by
1:15. In that event, I have to adjourn the matter today, because in next half I will take other matters.
Then my lords may give me a short date, even otherwise I have an appointment.
But in the meantime, don't take steps against the petitioner. Otherwise, this entire exercise will be infructuous.
That my learned friend Mr. Bilwadal will take care
Yes,
of.
Mr.
Since they have filed, there is no allegation.
And Mr. Shankara, one short note.
Absolute
note.
Two
Because there are
pages.
several matters, but that note will be confined to the FIRs, particulars of which are disclosed in the writ petition.
Yes.
Only 4 FIRs. That's the prayers. The prayers are restricted to 4 FIRs. Out of that, Siliguri, my esteemed senior friend, my esteemed
But
senior
it
has
is juniors
submitted.
are there. They are to advise your client. But so far, this writ petition is concerned, though you have relied upon.
So it's basically 3.
Justice Mantha's order. Justice Mantha's order.
Yes.
That there was a blanket order that
Yes.
not to initiate any proceedings without the leave of the court. But court today is considering, since in a previous writ petition an order was passed already.
Yes.
So therefore, this writ petition will be confined to the 4 prosecutions.
3 now. Siliguri, nothing.
No,
It's
I
only a
think-
child ID.
3 prosecutions where particulars are provided. But I want a short note on
I'll
those
give that.
3 on those 3 prosecutions, as you have indicated, referring to relevant parts of the complaints, in order to demonstrate vagueness of those complaints.
We'll do that. I just have one small plea,
Yes.
which is that earlier order which was referred to in the Adhikari matter, that is in this compilation, if your lordships can see, if your lordship will consider that. That's dated 6th September 2021, and it's the first order in that
Just a minute.
compilation.
This
I'm
is
sorry.
the compilation of respondents.
Yeah.
Your compilation.
It starts like this with this.
Just a minute. Just a minute. This
But
bunch.
yes. That
yes.
very first one.
Yes.
So it'll be the effective. I think,
You have relied upon 25522 of 2022.
Yes.
And
And
also, you have relied upon another judgment.
yes, serial number 2 and serial number 5 are what I had relied on. I'm now.
Just a minute.
Yes.
Yes, serial number
Yes.
5 you have relied upon 11032.
Then I read serial number 2, which was 25522. Serial number 1 is what I'm showing your lordship, because your lordship said the earlier order existed in Suvendu's case. Therefore, we will.
No, they are also, I have noticed in the order, yes.
Yes, but
That
there,
are
He
there-
cannot,
so
my lord, refer
just-
to the Honorable Chief Minister as Subhendu, my lord.
Wait, wait,
You know, at least, my lord,
it's a
he should have
precedent.
the decorum
Just
to
one-
refer
just one-
to the Honorable Chief
we
Minister's case
referred
or the
to-
leader of the opposition.
I'm
case.
sorry. Here I'm
This is
referring.
not the practice, my lord.
I-
Which is,
you-
I heard a passing
You
comment,
may
my lord.
out Herod, but
No.
Bhajan Lal,
I heard
Bhajan
a
Lal
passing
was the
observation or
chief
a comment, my
minister.
lord, about our institution
Bhajan
also.
Lal was the
When
chief
Mr. Raju was
minister.
arguing,
Please.
this is also not
This
the
is
way,
a
my lord.
precedent. I'm
I
sorry.
appreciate your sentiment. Yes. Yes.
Can I just say what I need to respond to this? When we refer to precedents as lawyers in court, we are not concerned with the status of those individuals.
Name
Keshav Nanda Bharati is Keshav Nanda Bharati, Golaknath is Golaknath, Bhajan Lal, the chief minister, is referred to as Bhajan Lal, Devi Lal is Devi Lal, VP
Bhajan
Singh
Lal
is
was
VP
the state
Singh.
of Haryana.
I'm
It's
sorry.
not Subhendu.
I am not
Well,
concerned.
let us come to the
Next
point.
door friend.
Let us come to the point.
So now since he has got his brownie points,
Time.
can we just
Not about having brownie points.
if you just see
state
that
law
I
is
appreciate your sentiment.
if you see that first order,
grateful to your lordship.
there's and I want to make it clear, no insult at all intended
Yes,
to the chief minister.
Question
At all.
does not arise.
It's
Yes.
not. I was just
Why-
referring to
why
the
could
order
you?
quickly. So, if your lordship comes to the concluding part of that first order, my lords, and the directions there, last page 19 of that very first order, page 19,
8 December 2022 order.
6 September 21. 6 September 21. The very first one in WP 11803.
Oh, as per serial number
As
1.
per serial number 1. Yes, my lords. So the first order is 6 September. It's a
Yes.
sizable order, about 20 pages. So at page 19,
Just
My lord just asked him to give a small note, but he's re-arguing the matter. I'm sorry.
yes, just yes.
My lord just asked him to give a note. He's fully argued. Now he's re-arguing the matter. But I'm sorry.
No. Only thing one,
Mr.
he will point it out today. It will be
Lord-
adjourned, and if you have anything to say,
Mr.
Mr. Raju,
Miss-
you will make submission on
No,
the
You
I-
only asked to give a note. You're not
Mr.
asked. to-
Raju, your
But, sir,
interruptions
you're
are not
re-arguing the
called
matter.
for.
Give him
I
an
didn't
inch and he
interrupt
takes a
once
yard.
when they didn't give me the
Mr.
copies of any of the judgments they relied on.
He was just asked,
What's-
but with greatest respect, he was only
please,
asked to
Mr.
give a
Raju,
written
you will
note.
be
Now he's
permitted-
re-arguing the matter. I'm sorry, my lord. This is not fair.
It's a
on this-
rejoinder, if at all.
I understand since Mr. Shankaran has completed his submission and thereafter you made submission against his replying.
Yeah, he has to give a rejoinder or he has to give a note. I have
clarification?
not completed
I'm
my
sorry,
submission.
this is
Any-
about the relief today, which your lordships are formulating for
any-
today.
No, I have not
Otherwise,
finished my submissions. I'm
Any
sorry.
clarification which is required to be made, you will be permitted to argue on the next date for a limited.
That's fair.
I have
No
no
issue.
quarrel as far as the court is concerned.
issue,
My
because
lord
this
just
court
asked
wants
him
to
give
give
a
you
note.
all
Instead of
ample
giving a note, he's
opportunity
re-arguing the
to
matter.
advance your argument.
I'm
He's
grateful.
taking
So page
liberty with the
19, my
court,
lords,
lord.
page 19,
Liberty.
the lordships may see in the middle of the page. This is that earlier order,
Yes.
the one that's referred to.
Yes.
In the third paragraph, there shall be a stay of proceedings in respect of so-and-so. The investigation into the other 2 police station cases dated so-and-so may go on, but no coercive action shall be taken against the petitioner. The petitioner shall cooperate in the investigation. So-and-so shall also remain state. The state shall furnish information in regards any other FIR registered against the petitioner is covered by my prayer. The state shall also obtain leave of this court before arresting the petitioner, because in the later order, your lordships will recall, they gave an order saying leave will be taken to register an FIR even. Now, if your lordships are not inclined to look at the later order, this is the earlier order. In the earlier order, this leave, I'm seeking, my lords, this small order I may be granted today, because coercive steps and a stay of any
This information you require.
all 3. One is the stay of coercive steps. Second is the information may be solicited from them.
I can't give
The
an
third
information,
is
but I'm
no
sorry.
coercive steps without the
I'm
leave of the
sorry.
court.
Information can't be allowed at this stage.
That the court will
Information-
decide, Mr. Raju, please.
Investigation is, how can the investigation papers be, what is contents of investigation papers be handed? This is not the stage to give him information. I may be heard on this point. No information can be provided.
I am not going to pass the order in the line of the order which has been relied upon by Mr. Shankaran. Then I would have heard you. I am simply adjourning the
Lords
matter
had
for further consideration,
indicated to Mr. Bilwadal that as far as
directing the
keep
respondents
your hands off,
not
that
to
we are
take any
agreeing.
steps against the
We are
petitioner.
agreeing.
Not
There's a
beyond
question.
that.
Yes.
Not beyond that.
That Mr. Bilwadal has agreed.
Yes.
Then there's the question of passing any order at this
See,
stage.
Mr. Raju, many things are said before this court. That does not mean that court is going to accept this.
I leave it to my lords.
Yes, yes.
Marat,
matter is-
kindly
matter
fix
is
it on a
under
date, my lord, convenient to my learned senior, my lord.
Yes, yes.
He'll come physically.
Sir, which date will be convenient, sir?
Issue a writ petition is heard at length in presence of the learned counsels, learned counsel representing petitioner, state respondents and investigating officer.
But we are for the state, my lord.
All are for the state Solicitor General and
But
additional
the
Solicitor General.
learned Solicitor General of India, learned ASG Raju, the learned
All,
Advocate General.
Mr. Raju and SG and ASG or both are appearing for the state.
Yes, yes.
One is,
State, but
one is appealing for the state, one is for the IO. my lord.
For the IO, for the
petitioner and
state.
representing the state respondents. Stop. Hearing is not concluded. Stop. Issue needs to be gone into further. Stop. Next paragraph. List the matter.
Any day.
When you will be able to come.
On
No,
6th.
Possibly I may have
And
to do
Mr.
it.
Raju,
Depends on
according
my
to your
calendar.
diary.
On the 6th.
Yes.
6th, my lord, 6th is convenient to me, 6th.
Very good. List the matter under the same heading list the matter under the same heading at the top on 6th August 2026 for further consideration. No coercive steps.
But that is not required, my lord. Till now, my lord, there has been no allegation also that there is any coercive step.
Let him give an undertaking.
Let it. Let it. Nothing has happened.
Since hearing is not concluded,
Yes.
Concerned respondent authorities are directed not to take any step against the petitioner.
With regard to, my lord, the three.
Against the petitioner.
No, with
Against the
regard to the
petitioner.
three
There's
FIRs.
a list which were given.
With regard to the three FIRs, my lord, is referred to the in the
this
order,
is-
my lord.
With regard to the FIRs referred to in the prayer of the petition.
Waited for such a long time. Wait for 6th of August.
Yeah,
Mr. Bhattacharya.
Nothing will happen.
So I find my learned friend also referring to, my lord, an interrogation in connection with the enforcement directorate. He says that this is harassment. He goes, kindly appreciates, my lord. He goes and appears pursuant to orders passed by my lord. He has pleaded that this is harassment. I have appeared before the police. The police are, he never mentions that no, it is pursuant to orders upon being directed by your lordship. He never mentions that. So if this is, my lord, his degree of honesty, I'll say, I'm using the word consciously, my lord. As the question arises, my lord, if by taking advantage of this, because here only the state is here. In the box, he has specifically stated that the ED have been summoned by the ED, so that is also state persecution. Should have a whiff of, my lord, I mean, what he is pleading or what he is signing on.
All compliances have been narrated, which was there up to the date, 2nd July. Up to 2nd
I'll
July.
take your lordship through everything. And so far as my lord Shubhendu Adhikari versus State of West Bengal is concerned, and that is how we refer to
How many
judgments, my
people
lord.
are going to argue, my lords?
I'll distinguish. I have the petitions. I'll show, my lord, what it was, and it's completely distinct and different, my lord. Completely distinct and different. There, the prayer was, an alternative prayer was made.
Take any steps against the petitioner.
With respect to the FIR prayer, my lord.
Yes.
Page 11. Page 11. Page 11. 1 minute.
In connection with following criminal prosecutions, : Roman 1, Bhavanipur Police Station, case number 121, dated 27th May 2026. Roman 2, Shiliguri Police Station.
Shiliguri is jailed ID.
Then
Kalitala Police Station, case number 140 of 2026, dated 16 June 2026. 3, Bishnupur Police Station, case number 668 of 2026, dated 16 June 2026.
And, my lord, serial number 8 is that complaint which has now become an FIR, which we have put in the writ petition. I'm not dealing with the supplementary affidavit. It's FIR 753 of 26. It's from the chart. Serial number 8, FIR 753.
There's no prayer for quashing, brother. There's no prayer for quashing.
At
I'm sorry.
Bishnupur. At Bishnupur.
Yes, but there the particulars are not given.
Complaint is on record. FIR was registered after I filed my
Not on
rate.
record.
So it's FIR 753 of
The
26.
complaint is not on record. There is no
Bishnupur.
prayer in the
Where
regard
can
with
you get the
respect to
FIR?
this. How can
Subsequently,
it
it
be
was
granted?
Yes, fourth. I told your lordship.
No, if I do this, then I have to extend this thing so far other proceedings are concerned.
No, only this one we know, my lord.
Cannot be
can
done
it- how can
directly,
it be
cannot
those
be done
other
indirectly.
informant
There
is
is an
not by the
undertaking
party.
that he
I'm
will
sorry.
not be relying on the
Informant is
supplementary
not by the
affidavit.
party
I
also.
need to extend the scope of the writ
My
petition so far
concern-
other
Trying to do that.
so far other particulars which are incorporated in the chart, pages 11 and 12.
But then your lordship give me leave to file a supplementary affidavit now. Now,
This
since
is
it's being
not
adjourned,
right, my lord. He had,
I'm
at
sorry.
the outset, he had undertaken that he will be arguing only regarding this.
I'm not
Now
accustomed
that the
to this.
matter is over,
I don't
he's
need-
saying, my lord, we are also
Mr.
not
Bhattacharya is
accustomed to these
because at
practices,
the
my lord.
outset, Mr. Shankaran, I
Cannot
have
blow hot and cold at the
specifically
same time.
asked you,
Can the judge speak?
I have
I am
specifically-
submitting to the
understand.
honorable judge. I do not look at the person
I
on my
have
right or left.
specifically asked you that whether you are praying for time to file a supplementary.
And I said no.
You said no.
Yes.
And you also submitted that
Yes.
so far present writ petition is concerned, that will be restricted to the
That's correct.
FIRs,
That's correct.
particulars of which are disclosed.
That's correct. But I said, to be fair, my lords, that I'm relying on my prayers. My prayers say that they can't keep going forward like this and registering more FIRs. That's
Be
my
fair
prayer.
when you're saying
And that's the
something
one I'm
is-
pressing to.
That will be considered on the next.
Your lordship may consider. Very well.
Yes.
My lords, can I just request that they give a list? I'm not asking for documents. List of the FIRs they have registered against me.
There
I
is
don't
no
think that's
prayer
too
as
much
such.
for a
It will be
citizen to
arguing
ask.
Under
for.
which provision we are required to give?
I have asked for documents. There was an objection regarding documents.
The list you provide.
List
Well,
can be provided.
Such
my
a
lord,
list you
No,
provide.
list is there. All FIRs are put on the web, my lord. He can get it
Next
from the
paragraph,
web. All FIRs are uploaded.
Concerned police authorities are
but
directed
at
to
least there
provide-
should be a prayer, my lord. There is no prayer regarding.
Prayer. It's a
There is
special
a,
prayer.
it's just a certiorari calling for the
Concerned
record.
police authorities are directed to provide a list containing particulars of FIR which are registered against the petitioner as on date.
Grateful.
But there is
I'm
no
very
prayer to that effect. It is only certiorari pertaining to the records pertaining. My lord, the records are confined to those
Mr.
four.
Bhattacharya, at least the proceedings which have been drawn up
Yeah,
against
at least
the
there should be
petitioner,
a
petitioner
prayer,
has the
my lord.
right to get the
My
information.
The
information
information is loaded on the website. Information
That
is
cannot be
uploaded on the website.
They're available on the website, my lord.
No, if it is available in the website, then what is the harm in providing a
Difficulty is,
in
my
other
lord,
matters? Every day, court is directing DIG or the Commissioner of Police Kolkata. If prior to election, court had to pass certain other orders.
What
Now,
can,
may
my
I
lord, what
tell
can
me
the
what is the difficulty? May I
I'm
tell
most
what is the
grateful for a
difficulty?
patient hearing, my
No,
lords.
may I tell what is the difficulty?
I'll give you a shot.
Not very
I'll
precise.
make
My
sure.
lord, may I tell what is the difficulty?
grateful.
Lord? May I tell
Yes.
what is the difficulty? Suppose in
Yes.
FIR there are 200 accused. He may be one of the accused. We may not be aware that he's one of the accused. We'll have to do a lengthy exercise. How do we know
So
that?
only those FIRs where petitioner is one of the accused,
But we'll
supply
have to
the
do
list of
supposing
those
there are 250 accused. We'll have to
Yes, fair
search
enough.
everywhere.
That's all I want.
I should we are
Don't
not
object to
supposed
that at least.
But
we can give a
difficulty is a general diary. He sees a general diary as an FIR also. He makes a prayer. But general diary cannot be uploaded.
But Mr. Bhattacharya, that is
He is under
Mr. Bhattacharya,
misconception.
Mr. Raju, that is not that those prayers are not entertained. And this court has also made it very clear that so far this present writ petition is concerned, that will be confined
Only to these three cases.
But
May I only
petitioner has the
suggest,
right
may I
to
only
get
suggest
information
this?
with regard to the pending cases.
May I suggest this, my lord? We will give him a list of all those FIRs which are not uploaded. Uploaded, he'll get it from the web. All those which are not uploaded, we'll give him. Otherwise, why
It should
give
have
him?
been uploaded.
There should
You
not be
just said it's all
bargaining to that
uploaded.
extent.
If
When
therefore,
none other than
no, I'm
additional
saying
Solicitor
if
General
not
of
uploaded,
India is
if not
happy
uploaded, we have uploaded everything.
Yes.
I'm most grateful, my lords. Most grateful. Very sad. Very sad.
Not very sad.
Item number 14.
Wait, His Lordship.
I am for the state.
Just a minute.
I am for the state.
You appear for the state. Please inform Mr. Bilodal Bhattacharjee. After this matter, are you appearing in this matter?
Well, this is the affidavit of
Mr.
service.
Ganguly, please tell your any of your juniors to inform either Shobhusachi Banerjee or On Bhattacharjee.
My lord, may I file the police report? On the last occasion, I guess.
Well, your Lordship had directed us to implead the de facto complainants as parties.
Just a minute.
Yes.
Service complete.
No, my lord, in respect of the first one, Taratola 75, it is complete, the de facto complaint. In respect of the next one, 76, it has come back as addressee. No such address exists. Now, if your Lordship kindly sees page 50 of the app.
Writ petition.
Yes. Kindly sees the address.
50.
Page 50. 50.
15.
No, 50. 50.
50.
Well, the address of the complainant is at the top. 1 number Jhupri Brace Bridge Station Road, Taratola. Now, very difficult to, I don't think, I mean, whether it's a recognized address or not.
Well, place your case.
Well, this petitioner, well, he is a member of the political party which was earlier in power, and he was a councillor of ward number 80 of the KMC. Well, he resigned therefrom on 8th of June 2026 after the results being declared. Now, 2 cases have been started against him on the same day, virtually at the same point of time, in respect of incidents which has taken place 1.5 years back, and in respect of the other about 16 months. That means 1 year, 4 months back, one after another, Taratola PS case number 75 and 76 of the same date, alleging that certain monies were paid by him to him. Well, if your Lordship kindly sees page 51 is the first FIR.
Yes, page 51.
I'm sorry, not page 50. I'm sorry, 46. I'm extremely sorry. This is the first FIR against me.
Executive magistrates.
The date of incident is on 29th of December 2024. Well, the second paragraph. On this, at about 18:30 hours, Anwar Khan, that's me, and 2 or 3 other, this came to my brother's office at this, demanded money as extortion by saying in Hindi, 1 तारीख को दादा का बर्थडे है, उसके लिए 1 लाख रुपया देना पड़ेगा. My brother did not have so much rupees at that time. Then Muhammad Anwar Khan and his men threatened him by saying, then this, it's in idle extracted portion. Out of fear for his life, he could arrange this.
Online.
Yes, as well as. Well, my specific instruction is that the petitioner has not received any money from him. He has, however, claimed to have annexed certain documents. I don't know, the state would definitely have copies thereof. Now, what is important is also, my lord, if your Lordship kindly sees page 42. Page 42, my lord. The formal part of the FIR.
Page 42.
Well, kindly sees the occurrence of offense. Well, it's just after the sections, the occurrence of offense. Kindly sees the date from 29, 20, 12, 24 to
And then just after that, 42, my lord. My lord, just after the Bharatiya Nyaya Sanhita on the left, your lordship will find. Then after that, occurrence of offense.
Yes. December 2024.
Yes. And then just
So
after.
yes, that is written on the in the complaint also.
Yes. And the date of information is 28/6. Just after that column, information received at PS 28/6/2026. That's after 1.5 years. And your lordship has seen the FIR. There is no explanation as to why the delay is there. Now, if your lordship now kindly sees the other complaint, the FIR, formal FIR at page 49. Well, this same column, if your lordship kindly sees, page 49.
This is the second FIR.
Yes, my lord. Started on
76,
the same.
yes.
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 20th of February 2025. My lord,
Date, yes.
Yes. 20th
Occurrence of offense 20th December 20th February 2025.
And the information is on 28th of June. So after nearly 16 months. And both are being filed at the same point of time.
So what was the complaint so far? FIR 76?
Page 53.
Page 53.
My lord, is this complaint in the second one? Here there is an allegation that for construction of toilets, 2 lakhs was demanded.
Ganguly, just a minute. Come forward. In Abhishek Banerjee's matter, which was heard in the first term, throughout the first term, the order which he passed directing not to take coercive steps is till 17th August.
17th August.
Because no date was fixed in this
Wait,
order.
but I'll
Time of
communicate.
correction I made it. So therefore I thought it fit.
And
to-
returnable on 5th, my lord, sir.
It is returnable on 6th.
6th, my lord. And 17th.
Do you have to inform Mr. Bilodal Lordship?
Yes, I have
I shall.
called Mr. Bhattacharya
Immediately after
because
going
it
out of
was
the
not it dictated at the time of dictating the order.
The date was not given, my lord. I'll deeply obliged.
I shall send for him.
My lord, I'm sending words.
Yes.
Yes. May I take your lordship's leave, my lord? May I take your lordship's? Page 53 is the letter of complaint.
Yes.
And only one line is there, which according to them explains the 16 months of delay is now at present I have gained my faith in the administration.
Where, which paragraph?
Well, just the penultimate paragraph.
Yes.
Now at present, I'm sorry, it's a bit.
Faith of administration.
Now at present, I have gained my faith on the administration in the first.
Yes.
My lord, may I file the report of the local?
I have not called for any report.
My lord, before
Today, court
this
is considering because there 2 criminal prosecutions have been initiated by registering FIRs. Then prayer is made for quashment of those prosecutions.
Yes.
Court is considering to pass an interim order.
I tell you,
That yes, very well, let the investigations be carried on, but no coercive steps against the petitioner in view of delay.
Before recess, lastly I came, I have heard the argument of Mr. S.B. Raju, senior counsel. My senior counsel referred 2 points, and my lord really considered those 2 points. One is delay ground, cannot be the ground for quashing of the quashing, and the first one is when there is substantive allegation.
Substance?
Allegation. The proceedings can be on. That cannot be quashed. So these 2 things I gathered from you. Really, I learned. I didn't know this.
Well, in response, I would say after that, your lordship granted the.
Lordship granted the leave because of the.
No, my lord had granted no coercive steps after that.
No, because of the detail. But I say very lengthy hearing.
See, that this from the formal FIR it appears so far FIR number 75 is concerned. This incident allegedly took place on 29 December 2024 and it was complained of on 28 June 2026.
They
Contemporaneously steps were not taken by lodging complaint.
True. They were so.
Mr. Bhattacharya, come forward in that matter, which I heard in the first half. I passed an order, but it did not indicate any date that up to which this protection is to be granted.
Fixed is on the 5th of August.
Yes, 70 up to 17th August I have stayed.
Up to 17th. Huh?
Sixth fixed, 17 up to 17 it will continue. Since at the time of dictating it was not indicated, that's why I thought it fit to inform the London advocates. Yes.
Can you keep it till the 12th, my lord? 6th, my lord has fixed it.
It will be there.
My lord, they are so powerful, man, for whom these two persons worked. It was before election.
Very well, you interrogate them. They let the
They
investigation
are
be.
absconding, not facing.
No, I'll direct them to cooperate with the investigation. Who is absconding? Petitioner is not absconding.
No. They are not facing.
I will direct the petitioner to cooperate with the investigating
washing at
agency,
this stage.
and appear before the police authorities as per notices.
Now, my lord, the main complaint for which the petitioners were impleaded, the London Council has not turned up. He has to make a submission.
How do you know that London Council will?
No, it is no, he is not there before your lordship.
In respect of the second one, my lord, if I may humbly pray, if your lordship will supply a copy to the learned councils for the state, if the state could ensure the service through the IO upon the complainant, I leave it to your lordship's consideration, because we could not do it by the normal postal.
No, কি বললে?
I বললাম যে local police station দিয়ে যদি সার্ভিসটা করিয়ে দেন upon the second one also. কারণ ওকে তো ফেরত এসছে না।
Affidavit of service in terms of previous order, affidavit of service filed on behalf of the petitioner is taken on record.
Second. Well, with your lordship's leave, I have two judgment orders of your lordship.
Yes. Where I relied upon
Iqbal Haji.
Haji.
Yes, my lord,
Well, may I have copies? আরেকটা দাও।
আরেকটা কি রে? না আমি দুটো দিয়েছিস তো।
ইকবাল হাজিটা কোথায়?
ওই তো এটা না ইকবাল হাজি এখানে
In spite, though complainant in case number 75 was served.
Yes.
Complainant in case number 75 is respondent number 6.
Is respondent number 5.
Though respondent number 5 was served with notice, but in spite of making attempt, respondent number 6 is next paragraph. By presenting this writ petition inter alia, two criminal prosecutions, namely Taratola Police Station case number 75 of 2026, dated 20 June 2026, and Taratara Police Station, case number 76 of 2026, dated 28 June 2026, are assailed. Stop. Mr. Sandipon Ganguly, learned senior advocate representing petitioner, has drawn attention of this court to respective complaints being genesis of aforesaid two criminal prosecutions, one dated 28 June 2026 and another
Same date, my lord.
dated 29 June 2026. Page 53 at the top right hand side.
My lord, no, my lord, my lord, that's the scene by the learned ACJM. Your lordship will get it at page 49.
June. আচ্ছা, তাহলে দেখি attention of this court has been drawn to both dated 28 June 2026. Stop. In reference to these two complaints, it is submitted that in connection with alleged incident of demanding money by the petitioner, which took place on 29 December 2024 and 20th February 2025, complaints were lodged on 28 June 2026. Stop. It is submitted that petitioner belongs to a particular political party and was councillor of Kolkata Municipal
Ward 80.
Kolkata Municipal Corporation, after declaration of result of Assembly election 2026 on 4th of May 2026, in order to unleash political vendetta, such frivolous complaints were lodged. Next paragraph. State respondents are represented by your name?
Debashish Choudhury.
State respondents are represented by Mr. Debashish Choudhury
And Mr. Bikash Chandra Das.
learned advocate, who has opposed this writ petition. And it is submitted that once criminal prosecutions are initiated against the petitioner, investigating agencies are required to grant opportunity to complete investigation and file report before jurisdictional magistrate. Stop. Next paragraph. Having taken note of the submissions made on behalf of respective parties and contents of the complaints dated 28 June 2026, it appears that contemporaneously de facto complainants did not take steps by lodging complaint before the concerned police authorities alleging demand of money by the petitioner. In the complaint dated in the complaint of Bikash Singh, being respondent number 5, it has been alleged On 29 December 2024, petitioner demanded money illegally,
and in complaint of one Sujit Valmiki, it was alleged that on 20 February 2025, petitioner demanded money, being counselor. Whereas complaints were lodged more than 1 year thereafter, giving rise to aforesaid criminal prosecutions. Stop.
Thirteen, 14, 15, 16.
শোনো প্যারাগ্রাফ 11টা এরপরে সেট আউট করে দেবে, মানে সেট আউট মানে কোট আনকোট না, জাস্ট যেরকম ভাবে আছে। নেক্সট প্যারাগ্রাফ।
At this stage, court is contemplating to pass an interim order in consideration of balance of convenience and inconvenience. Stop. When complaints are lodged after a long period of time, considering date of alleged offense, and moreover, complaint was lodged after declaration of result of West Bengal Assembly election 2026 on 4th May 2026. It is found apt to direct the concerned police authorities not to take coercive steps against the petitioner. Stop. Petitioner is a political person, and to unleash political vendetta, such complaints may have been filed. Stop. However, veracity of the complaints are not required to be looked into by this court at this stage. Stop.
Next paragraph. Respondent concerned police authorities are directed not to take any coercive steps against the petitioner till November 2026 or until further order. Stop. However, petitioner shall cooperate with the investigation and make himself and appear before the investigating officer pursuant to the notices to be issued to the petitioner. Stop. Next paragraph. In the event petitioner does not cooperate with the investigation, same shall be brought to the notice of this court by the state respondents seeking vacation or variation of the order passed to them. Leave is granted to the state respondents to bring it to the notice of this court in the event petitioner does not cooperate with the investigating officer for vacation or variation of the order passed to them. Next paragraph. List the matter under the same heading for further consideration on 16 November 70. List the matter under the same consideration. List the matter under the same heading for further consideration on 12th November 2026.
Maybe just after that 16th. I'm sorry. That first week I may not be there.
16th, you have difficulty.
No, your lordship has kept it on the 12th. If it may be on the 16th of November. 12th is the reopening.
Right.
12, 13, I may not be there. That's why. If it can be on the 16th, subject to your lordship's pleasure.
ওটাকে 30th November করে দাও।
I'm deep.
30th of November, matter to appear on 19th November.
I'm deeply obliged. And my lord, one indulgence may I pray for? At page 34, if your lordship kindly sees...
Yes, service.
No, the list of any other materials on
No
the...
other material. With this police station, so far as this police station
no.
is concerned, no other criminal activities.
Next paragraph on the next date. Concerned police authorities shall file a list of criminal prosecutions if any pending against the petition.
I'm deeply obliged.
আরেকটা line add করো. Officer in charge, Taratala Police Station, being restaurant number 4, is directed to make an attempt to serve notice, to serve copy of the writ petition and the order passed today upon respondent number 6, since it is submitted on behalf of the petitioner that in spite of making attempt, respondent number 6 could not be served.
Well, should we supply a copy to
Yes.
the learned counsel?
Learned advocate for the petitioner is directed to supply copy of the writ petition and the copy of the writ petition to the learned advocate representing the state.
Let them have a Xerox from
By
the police
7.
station.
By 7.
Or I don't know. Jodi bolen, I can
No,
go and
please do,
directly
please
submit
do,
it.
please
Then
do.
let us. It's not required. I'll serve directly.
To the officer in charge.
Officer in charge.
Learned advocate for the petitioner is directed to supply copy of the writ petition and the order passed today upon officer in charge Taratala Police Station, being respondent number 4 by 7 days from
empty.
My lord, I'm sorry for the trouble being taken for me. Your lordship's pleasure is to, direction is to matter to appear on 19th of November.
30th November.
30th November. And till 19th, I have heard my lord it has gone down.
Matter to appear on 19th.
I bow down to your lordship, my lord.
Till 30th November until further order, whichever is earlier.
ঠিক আছে। চলো।
Item number 15. 15, your lordship, I am for the petitioner. A fight between two brothers. A fight between two brothers over property dispute. After filing of this writ petition, they have amicably settled the matter, your lordship.
Settle the matter.
My lord. Your lordship may record my submission and dispose.
Lordship, I have a report to place.
Issue. I have not called for a report. It is up to you, sent to you.
If you
See,
Yes,
to the learned
addressed to me, addressed to
government
me. Yes,
advocate.
your lordship, it's addressed to me.
At the time, affidavit of service filed on where
Yeah,
the
it's okay.
petitioner is taken on record. Next paragraph. Learned advocate for the petitioner submits that if feud between two brothers is settled out of court, and as such petitioner is not pressed. Next paragraph, state respondents are represented by learned advocate. Next paragraph. In view of efforts of submission, no further order need be passed on this writ petition, and the writ petition is disposed of. Parties to act on the server copy. Next,
my lord. Item number 16. My lord, I appear on behalf of the petitioners, my lord.
My lord, I beg to appear for the state.
My lord, my
Yes.
affidavit of service, my lord. My lord, this matter was taken up last week, my lord. However, the private respondents did not appear. Therefore, my lord had sought to fix this matter today, my lord. My lord,
Yes.
kindly comes to page number, my lord, 60, my lord. The grievance of the petitioner is that the petitioner is not allowed to construct over her own property.
Petitioner
is not able to construct a building, my lord. The petitioner has all the sanction plan and requisite permissions. However, my lord, the petitioner is being stopped by the private respondents from constructing, my lord, in a very, if my lord comes to my representation to the police, my lord, page number 60, my lord. I have annexed, my lord. The petitioners are constantly obstructing the passage of the construction materials to the said plot of the petitioner's, my lord. Now, my lord, the petitioner in this, my lord.
now, private respondents must have obstructed you from making construction.
My lord.
So they are required to be heard, or otherwise it's a dispute which needs to be considered by the Kolkata. If it is within the Kolkata,
My lord, it is
or
Maheshwara
under Kolkata
municipality, my
Municipal
lord.
Corporation, then it needs to be considered by
My
the
lord, the
corporation.
obstruction is
Why the police authority will be directed?
My-
If there is a dispute with regard to the property in question, then giving direction upon the police authorities to take steps which will permit the petitioner to make construction, that may deny right of the private respondents.
My lord, if I may, my lord, the plot of land which the petitioner wants to develop, construct, my lord, it belongs to the petitioner. The problem is the private respondent is obstructing, my lord. There is a road, my lord. Now, from that road, my lord, when the material.
Where is your complaint?
My lord, my complaint is in page number 52, my lord. My lord, if my lord, police assistance is given to the petitioner, my lord, while my lord, the passage of the construction material is taken to the plot, my lord, the petitioner's right will be
Page
subserved.
32.
Page 52, my lord.
52.
52. My lord, if I may place the complaint, my lord.
My lord, may I pray for a note today, my lord?
No, sorry. Then you ought to have prayed for time at the beginning, not now. With the intention.
My lord, I am led by a senior and he's not appearing.
Very
My lord,
good.
he's
You appear, that will be sufficient. In spite of obtaining sanction plan, why petitioner will be prevented from making construction? In spite of obtaining sanction plan, why petitioner will be prevented from making construction? That not by a persons who are residing adjacent to the premises of the petitioner. They are the local persons and creating trouble and not giving access to the vehicles carrying building materials to the construction site.
My lord, as per my instruction, there was an application filed before the executive magistrate as well, my lord. And there were report to be filed on 29th.
But did not yield any result. Still petitioner is lamenting.
No, it is also pending before the executive magistrate's court where the report has been
The
filed.
concerned police authority to file a report why petitioner is being prevented.
And I shall file my report. My lord.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. It is contended by the learned advocate representing the petitioner that in spite of obtaining necessary sanction plan from Kolkata Municipal Corporation, no, from Mohestala Municipality. From Mohestala Municipality, petitioner is being prevented by private respondents from making construction, prompting the petitioner to approach this court with the present writ petition. Have you served upon the private?
I have served the my lord, complete.
Next paragraph. In spite of service of notice, private respondent number 6 to 8 are not represented. Next paragraph. Officer in inspector in charge, Mohestala Police Station, being respondent number 5, is directed to cause an inquiry and submit a report as to why petitioner is being prevented from making construction. So let such report be filed by 10 days from date. Stop. List the matter under the same heading for further consideration on August 2026.
I'm grateful, my lord.
Collector Dago.
Item number 17. My lord, I beg to appear on behalf of the petitioners. My lord, in this matter, my lord, I would seek, my lord, not this week, my lord.
Yes.
My lord, I will seek not this week, my lord, on the ground that, my lord, the advocate on record is not in town, my lord.
On the ground?
On the ground of the advocate on record not being in Calcutta, my lord. He is outside the, therefore, my lord.
You are appearing in this matter?
My lord.
No use of keeping this matter pending because the prayer is made for registering FIR.
My lord, my lord.
To treat the petitioner's written complaint dated so and so as FIR and register the claim. Issue.
My instruction is that on 23rd.
FIR is registered.
No, my lord. On 23rd, before his complaint, wife has already registered, made a complaint and that has been registered.
Matter is heard in presence of the learned advocates representing the petitioner and state respondents. Stop. Next paragraph. From the case made out in this writ petition, it appears prayer is made for directing the concerned police authorities to register FIR based on complaint lodged. Next paragraph. There is an alternative remedy available to the petitioner under section 175(3) BNSS 2023. Stop. Petitioner needs to avail such remedy. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2007, Volume 6, SCC 171, Aliu Kadamsi and others versus Union of India. Next paragraph. In view of availability of alternative remedy, Writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in pursuit of remedy. All other matters. Yes, call the next matter.
Item number 18.
Not today.
Picked it August monthly list because another matter has been fixed by.
That will be considered later on or simply not today. Yes. Yes.
I said it's a short matter.
Yes. Call other matters. There is not much progress in the list today because of that matter in the first half. That's why, since you have made a prayer, I thought it fit to hear about the matter, but it is not possible. Since
I was balancing one.
Yes.
That took a long time, so this will take a short time.
Yes.
Item number 78.
Lordship may recollect this matter, matlab the SC/ST related matter. Lordship was pleased to kindly see the last order passed by you, Lordship.
ঠিক আছে FIR register হয়ে গেছে investigation being done by DSP order. Well, this can be disposed of. The FIR has been registered under the SCST Act and the IO has been assigned as the Deputy Superintendent of Police Border of Ranaghat Police District.
That was your
That was my
concern. That steps are not being taken in terms of the relevant provisions of
Yes,
the
yes,
statute.
রিপোর্টের একটা কপি দিয়ে দাও
গুড বয় হয়ে যাচ্ছে গুড বয় হয়ে যাচ্ছে সে না বলার আগে দিয়ে দিল থ্যাংক ইউ না সেটা নয় তুই যে আমাকে নিজে নিজে কপিটা দিয়ে দিলি অফকোর্স কিন্তু তোকে তো বলতে হবে না দিদি এই নিয়ে এখন তর্ক করবো 5 বছর পর করবো you will have I will have to give 5 years then the question will come শোনো কাজ যদি
What is the nomenclature of this act?
schedule
Stated in your
kindly have a look into section 18A
SCST Prevention of Atrocities Act.
it would constitute prevention of abuse.
Learned advocate represent Mr. Sujanil Das, learned additional government bidder representing state respondents, has filed a communication dated 30th July 2026 of officer in charge Gangarampur Police Station. No. Officer in charge Gangnapur Police Station. Gangnapur Police Station, Nodia. And same is taken on record. A copy of the said communication dated 30 July 2026 is made over to the learned advocate representing the petition. Next paragraph. Learned advocate representing the petitioner made submissions on earlier occasion that petitioner belongs to scheduled caste community, scheduled scheduled caste community. Therefore, complaint of the petitioner lodged before the concerned police authority and therefore steps are required to be taken based on the complaint made by the petitioner in terms of relevant provisions of the scheduled castes and the scheduled tribes. The scheduled tribes within bracket Prevention of Atrocities close bracket Act, 1989. 1989. The scheduled castes and the scheduled tribes within bracket Prevention of Atrocities close bracket Act, 1989. Next paragraph. It is contended on behalf of the state respondents in reference to contents of the communication dated 30 July 2026 filed today, that on preliminary inquiry, taking note of the complaint of the petitioner, 79 FIR is registered, being Gangnapur Police Station case number 190/26 dated 25th July 2026. Under certain provisions, under section 351 within bracket 2 BNS and section 3 within bracket 1 within bracket S of said Act of 1989. We said Act করে দেব herein after referred to as the said Act. Next paragraph. It is also disclosed in the communication that Deputy Superintendent of Police within bracket border close bracket of Ranaghat Police District is entrusted with the responsibility to act as investigating officer. Stop. Next paragraph. In view of aforesaid steps taken by the concerned police authorities, it appears that these are in consonance with the relevant provisions of the said Act of 1989. Next paragraph. Hence, no further order need be passed in this writ petition. Stop. Writ petition stands disposed of. Parties to act on the server copy. এটা দেখে নিয়ে ছবিটা তুলে নিয়ে একটু দিয়ে দাও এই জায়গাটা পরে আমি আনিয়ে দেব। Next.
Grateful, Lordship. Item number 79.
This is my application.
কত থেকে 79? Yes.
Where will I go? Ask for the report from my lab.
Yes. What is your instruction?
There is a case which has been registered. This is a prayer from my end, Lordship. If some more time could be given, I could inquire, because the allegations which are there in the complaint, that perhaps on the basis of that FIR has been registered.
Yes, 36, page 36, I have any state.
No, I'm trying to help out my learned friend over here. I'm not treating it as an adversarial litigation, at least at this moment. If I may come back, if I can speak to the police officers more thoroughly, maybe a better solution could be found out.
Copy of the report.
ওসি বাসন্তীকে বলবে আমাকে ফোন করতে।
Today, Mr. Sujanil Das, learned additional government pleader representing state respondents, has filed a communication dated 30 July 2026 of Inspector in charge Bashanti Police Station, and same is taken on record. Next paragraph. On behalf of the state respondents, accommodation is prayed for to take certain steps. Next paragraph. Writ petitioner is represented by learned advocate. Next paragraph. This the matter under the same next paragraph. Hearing of this matter stands urgent. Stop একই সঙ্গে দেবে stop দিন. List the matter under the same heading for further consideration on 24th August 2026.
Lordship, Lordship. 24th August. দরকার পড়লে এসপির সাথে কথা বলবে।
Item number 80.
Item number 81.
81, I am for the state.
I am for respondent number 4 and 5.
I am for the petitioner. And this is his.
You are for the private respondents.
Respondent number 4
Yes.
and 5.
What is the matter about?
This is the second round of litigation. Your lordship kindly directly turns to page 30. Earlier, the order passed by the coordinate bench. 17th of July 2025.
এর আগে একটা সেট অফ রিট পিটিশন হয়েছিল কানেক্টেড ম্যাটার্স ছিল একসাথে আমি আমার লাগলে এই যে উনি এটা রেফার করছেন ছিল পিস না পিসেস হুম
So you have filed this writ petition in view of the leave granted by the
Yes.
coordinator.
Only FIR has been
Problem is
registered.
this today, since you are not satisfied with the progress made in the investigation. But that is not today court is required to consider in view of Sujal Vishwas Attawar's judgment delivered by the Honorable Supreme Court.
Since my lord, liberty was granted by the honorable coordinate bench. My lord.
But that is the order of the coordinate bench where this judgment was not taken into consideration. Because at the stage that at the time when this order was passed,
At that point of
probably
time, there was no
this judgment of the Supreme Court was not passed, not delivered. So today I am bound by the judgment of the Supreme Court, where it was directed that if a party is dissatisfied with the steps taken by the investigating officer, in that event remedy lies before the jurisdiction magistrate.
My lord, since the respondent number 4 is the employee of the Kolkata police, my lord, by taking advantage of this situation, my lord, police authority till today, my lord, not filed the charge sheet also. In spite of fact, such
Yes, what is the progress made in the investigation?
Yes, my lord.
A detailed report has been submitted by the police authority.
Whether a report filed before the jurisdictional magistrate. 4th July 2025, it was initiated. FIR was registered.
Till today, my lord, charge sheet has not been filed before the jurisdictional magistrate.
Lordship, if I may say, I was called by the police authorities for investigation. I have visited, I have complied to all and cooperated as well. And I have submitted all the documents that were needed.
Now, my lord, it is the duty of the police authority to conclude the investigation by submitting the charge sheet.
My lord, perhaps as this is the old report, next date, if your lordship peruse,
তো কাল ছিল লোয়ার কোর্টে
30/6
কত
30/6 not filing of
Thank you.
একটা ছবি তুলে নেবো আপনার হয়ে গেলে
Four and five are accused persons.
Accused person. And respondent number 4 is, my lord, employee of Kolkata Police.
But there is another accused person, Gopal Halda, as it is disclosed in today's communication which is filed.
Lordship, if I may be permitted.
Arjun Saha and Sompa Saha.
For providing job, he took money from the petitioner and other unemployed youth.
And that is not revealed from this report, my lord.
But the coordinate bench granted liberty to the petitioner to approach this court. If the petitioners are agreed by the manner in which the investigation is progressing at a subsequent stage of the investigation, they may approach before this court. They may approach before this court by the coordinate bench, and no appeal was preferred against this order.
judgment of Sujal Shah Attawa
Have you preferred appeal against this order? Then
Because it was the earlier
Then-
location. We had no knowledge.
then try to conclude the investigation and submit a report. File a further report.
Yes, as your lordship. But one thing I must.
On behalf of the state respondents, a communication dated 28 June 2026 is filed today and same is taken on record. And a communication dated 28 June 26 of Inspector in charge Vishnupur Police Station is filed today and same is taken on record. Next paragraph, a learned advocate representing the petitioner added this file to the service taken note. Copy of the said communication dated 28 June 2026 is made over to the learned advocate representing the petitioner. Next paragraph, it is submitted on behalf of the petitioner that there is no substantial progress made in investigating Vishnupur Police Station case number 178 of 2025 dated 4th July 2025. Stop. In support of such contention, reliance is placed on the order of a coordinate bench dated 17 July 2025 passed on the writ petition filed by the petitioner being WPA 11027 of 2025 within bracket Partho Sarathi Saha versus the state of West Bengal. Stop. Next paragraph. It appears from the said order. Next paragraph. It appears from the said order dated 17 July 2025 that the coordinate bench granted leave to the petitioner to approach this court in the event petitioner is agreed by the manner of investigation being carried out by the concerned investigating agents. Stop. Placing reliance, taking note of leave granted by the coordinate bench video order dated 17 July 2025. Taking note since the coordinate bench has granted leave to the petitioner, video order dated 17 July 2025 to approach this court if petitioner is dissatisfied with steps taken while investigating aforesaid criminal prosecution. Comma. Investigating officer is directed to expedite investigation and submit report at an early date. Stop. An effort shall be made to complete the investigation by 6 weeks from date. Stop. Let a further report be filed by the investigating officer by 8 weeks from date. Stop. List the matter under the under the same heading for further consideration on. Date. No. On 29th September 2026. Complete the investigation when court directed.
As this is a financial fraud always takes time for investigation. This is the practical difficulty. I have seen in various occasions. In a murder case or any other criminal.
But at the same time, court cannot ignore the fact that the accused person is a member of discipline force.
That is absolutely.
Or the member of police. He is an employee of.
That is true. But
Of the concerned department.
Generally takes time.
That perhaps that might be the reason for in delaying the investigation.
Yes.
Lordship, we have complied. Lordship, we have complied to all.
I am not saying that you have not complied with. So that's why court in the coordinate bench also directed to expedite and granted leave.
I shall communicate with the person. And
Accused person is a member of police force.
yes, admitted that cannot be.
So there might be the reason for delaying the investigation.
But ultimately,
Very well, you complete the investigation, submit a report. Yes.
Either today or tomorrow. But
Yes, next.
Grateful, Lordship.
Item number 82.
My lord, I am for the petitioner, my lord. My lord,
kindly acknowledge.
Yes.
The order passed last occasion. Lordship engaged. And another person has been tagged as for state. That should be corrected.
Which?
The last order.
Very well, you pointed out on the next date. Yes, please call the next matter. Your name is there, that is sufficient. Yes.
No, in the body, but on the upper side, it is.
Your name is there.
আমি হলো পঞ্চায়েতের প্রধান আমাকে প্রোটেকশন দাও আমি যাতে
Another one name is
ডিউটি করি আমরা
Last occasion, my lord, someone has been paid for time on behalf of George ছিল বলে আপনার
না within time.
No, sorry. Yes. Please call the next matter.
Item number 82.
my lord, I am for the petitioner, my lord.
আমি কি পঞ্চায়েত
I am a Panchayat Pradhan.
Just a minute.
সাপ্লিমেন্টারি আমার এখানে একটা পোস্ট হোল ভায়োলেশনের
এই এটা দেখবে তো কোন ম্যাটারে আছে এটা ঢোকা। Yes.
But my first prayer, my lord, kindly come to page 19, first prayer. That commanding the respondent of 4 to 5 provide immediate round-the-clock police protection and home security to the petitioner and his entire family. So the petitioner, along with his wife, daughter, and sons, are safely returned to their home village, that is Sulkuni Daspara. 1. Number 2, he is I would kindly come to the 4th to provide adequate police protection, security to petitioner family members, residential premises, ancestral property, and other places to discharge his official duty as the Panchayat Pradhan of Bhavanipur 1 Gram Panchayat without any obstruction, intimidation.
If you cannot function as Panchayat Pradhan, approach Group 5 bench.
Rule 5A of the Panchayat Act.
Yes.
But when the police, so I cannot go. I also
Authority cannot compel or cannot take steps
so that Panchayat Pradhan can function.
My lord, it's after post-poll violence. My lord, what
Maybe.
happened after fourth? My lord, the situation was so hostile that so that I
So there
cannot.
are what are the other reasons so far that Panchayat, Gram Panchayat is concerned that needs to be taken into consideration. This court will not consider
My
this.
lord, the other protections, registered on the basis of my complaint. My lord, kindly see the may hand over
After
the
filing of the
supplementary.
petition.
No, before that.
May
Before that.
this is the supplementary affidavit, my lord. I have prepared.
21st May, if I registered.
Show me, yes. File your communication.
My lord, these I have disclosed the complaints which was
Yeah,
taken screen.
henceforth, no trust motion will be heard by this court
My lord, the
against the Pradhan.
Every 2.5 years.
my lord, that is we
That,
always.
that the police authorities will go and conduct the meeting.
My
of no
lord,
trust
we,
motion.
we normally call it it's a seasonal litigation, my lord. Seasonal.
Every 2.5 years. এবারে তো শেষ হয়ে যাবে।
This matter was filed on 19th May 2026. Today we are in the we are at the end
It
of
is
July.
continuing, my lord. It is continuing. At least, lordship, ask a report from them so that they can apprise your lordship. Situation has not improved, my lord. So that
And this report dated 2nd of June 2026. File a fresh report disclosing whether the petitioner is along with his family members are staying at his own residence or not. In the meantime, situation might have improved, might have been improved. Situation might have improved in the meantime.
Situation is more than normal.
Yes.
Are they ready to provide me some
is more than normal.
some security? If they are ready, I will go tomorrow, my lord.
In comparison with the 2021.
By present, affidavit service filed on supplementary affidavit filed on behalf of the petitioner is taken on record. Next paragraph, it is submitted on behalf of the petitioner that that prayer is made for directing the concerned police authorities to provide protection which would enable the petitioner to stay at his residence along with members of his family. Stop. It is submitted that petitioner is member of a Pradhan of Gram Panchayat. Petitioner is Pradhan of a Gram Panchayat. No, Pradhan of a Gram Panchayat. Stop. Next paragraph, on behalf of the state respondents, a communication dated 2nd June 2026 of Inspector in Charge, Hasnabad Police Station is filed and same is taken on record. Stop. Let this communication dated 2nd June 2026 is made over to the learned advocates representing the petitioner. Next paragraph, since this communication is dated 2nd June 2026, Inspector in Charge, Hasnabad Police Station is directed to cause further inquiry and file a report disclosing whether the petitioner is presently staying at his own residence or not. Stop. Let such report be filed by 10 days from date. List the matter under the same heading for further consideration on 24th August 2026.
By the time, lordship, only one thing that petitioner goes there and seek the assistance, they should.
By the time, nothing. Yes.
They should.
Next matter.
Item number 83.
19th May situation was volatile. Today situation
It was never abnormal.
Yes.
I'm for the petitioner, my lord. My lord, the private respondent number 10. My lord, what happened, my lord? My lord, the petitioner has complained against my lord, the private respondent. They have taken money, the promise of giving my lord government job, my lord. They have not given the my lord job. My lord, they have not also returned back the. Wait, okay.
Yes. Yes. What is your case?
My lord, the private respondent, they have taken money from the my lord, some person, my lord, for giving a government job. And 19 lakhs of rupees they have taken. Thereafter, my lord, they have not given the job and they have not also returned back the money. I file a complaint before the police authority. Police authority, my lord, case is started, but my lord, investigation is not done.
No,
My lord, no money
No,
was
if
recovered.
Charge
investigation
sheet
is
has
not
been
pro-
filed.
is not appropriately progressive.
Yes.
In that event, you have to approach the jurisdiction magistrate.
Lordship, charge sheet has been filed, charges have been framed. As a matter of fact, against the police officers, there's one allegation against certain police officials.
Yes, my lord.
A charge sheet has been filed against those in that case as well.
Lord, I am the charge sheeted person.
Already charge sheet filed.
And charges have been framed in one of the.
Copy of the report may be filed, my lord.
সে ঠিক আছে
You are complaining of manner of investigation. Already investigation is complete. Charge sheet
I
filed.
have no knowledge.
What remains? It is Kotwali Police Station case number 1218/2021.
Yes, my lord. Yes, my
Dated
lord.
12
First
December
case.
2021.
Yes, my lord. First case. Thereafter, my lord, another case was also filed. Because the police authority, after taking money, they are not doing anything. That is on 2026, 116 of 2026. Two cases was filed by me.
In respect of which prosecution charge sheet is
The
filed?
first case, Lordship,
That is
1218.
or 116?
1218. 116, 1218, charge sheet filed, cognizance taken, charges framed. 116, charge sheet has been filed, cognizance is awaited. Charge sheet has been filed in 116 on 25th of May, 2026.
Of May, that is connected to FIR dated 1218.
116.
116.
116. Which is against two delinquent police officials.
And with regard to 1218?
Charge sheet filed, cognizance taken, charges.
Where that particulars of charge sheet is disclosed?
Yes, Lordship, page 2 of my report. The small paragraph, the beginning with
yes,
on 28/1/2026.
Lord, I have a copy of the.
This is under trial. Issue. Last advocate representing petitioner expresses dissatisfaction regarding manner of investigation being carried out by the concerned police authority in connection with two criminal prosecutions. One is Kotwali Police Station case number 1218/2021 dated 20 December 2021, and another is Kotwali Police Station case number 116/26 dated 1st February 2026. Stop. Prayer is made for directing the investigating officer to expedite investigation and file report before the jurisdictional magistrate. Next paragraph. Mr. Das, learned additional government Peter, representing state respondents, has filed a communication dated 9 July 2026 of Inspector in Charge, Kotwali Police Station, and same is taken on record. So, copy of the said communication is made over to the learned advocate representing the petitioner. Next paragraph. It is disclosed in the communication that in connection with Kotwali Police Station case number 1218/2021 dated 20 December 2021, charge sheet was filed, charge was framed, and trial started. Stop. In connection with Kotwali Police Station case number 116/26 dated 1st February 2026, charge sheet dated 25th May 2026 was filed before the jurisdiction magistrate. Next paragraph. In view of aforesaid steps taken by the concerned police authorities, no order need be passed on this petition, and same stands disposed of. Parties to act on the server copy.
Grateful, man.
Grateful.
Item number 84. I beg to appear on behalf of the petitioner, my lord. The petitioner is a business correspondent of the State Bank of India in a similar matter, my lord. I'm sorry.
Have you served upon State Bank?
I'm served, man.
When served?
I served on 15th June 2026. They have received on 18th June 2026. May I find my affidavits? A similar order was passed in respect of another matter. The private respondent was different, but the matter is one and the same.
Well, do one thing, serve notice upon one Mr. Devashish Shah, learned advocate who generally represents State Bank of India.
Right.
Today also in one matter, today or day or yesterday he appeared before this court.
And I believe
Since the state SBI is not a represented to this court.
What
is the matter about? Your account is debit process.
I'm a business correspondent of the State Bank of India, man. My the sub agent, which is known as a customer service point, that person has siphoned off person.
I have passed one order.
One order, my the private respondent is different. This is the order my lord has passed in respect of the other matter. My lord has called for a report, but this is the private respondent is different, although the allegations are one and the same. And my lord had directed me to show this order when this called on.
That jano na.
Yes, what is your specific case here?
No, my lord, similar case, my lord. The private respondent, who is a customer service point, these are very remote locations where
Collected money and
collected money. Collected money and used it
as a result whereof
you lodged a complaint. FIR has been drawn up, but there is no progress.
No, not only there is no progress. These people are going, using my reputation, using the reputation of State Bank of India, going.
approach the jurisdictional magistrate.
But we will kindly see the urgency. My lord, if I may go to the jurisdictional magistrate,
Yes.
these people will siphon off more
Jurisdiction
money.
magistrate, sorry.
But will kindly appreciate this.
Have you disclosed the FIR?
My lord,
Where?
that, page 54, my lord. Page 54, 55. Today, his exact prayer for at least the inaction that he complains of against the police is that you recovered for me 1,52 lakhs. So police has become the recovery agent for the petition. No. For that, I am filing a civil suit. That is not the thing.
So
but
what will
this
police do?
at least these people should not collect more money. These people have to be apprehended. Otherwise, Now, they use the brand of State Bank of India. They go and collect. File my report showing what are the progress being made.
Yes, sure. Affidavit service filed on behalf of the petition is taken on record. Next paragraph. From the submissions made on behalf, from the case made out in this petition, it appears that petitioner is a business correspondent under State Bank of India. There are sub-agents / customer service point functioning under the petitioner, who collected money from villagers but did not invest the money with the bank. Stop. Alleging such incident petitioner lodged complaint with the concerned police authorities that gave rise to a criminal prosecution, being Rohora Police Station case number 9 of 2026, dated 19th January 2026. So, however, dissatisfaction is expressed on behalf of the petitioner with regard to progress made in the investigation, which prompts the petitioner to approach this court seeking direction upon the concerned police authority, seeking direction upon the police authorities to expedite the investigation. Stop. Prayer is made for recovery of the amount.
না কোর্ট কি
which is alleged, which is allegedly not invested by sub-agents / customer service point functioning under the petition. Next paragraph. If petitioner is aggrieved by inaction on the part of the concerned police authorities in not taking the investigation to its logical conclusion, or petitioner has grievance that police authority has not recovered the sum involved in the case, in that event petitioner needs to approach jurisdictional magistrate under section 175(3) under section 175(3) BNSS 2023. So in this regard, reliance is placed on the judgment of the Supreme Court reported in 2026 SCC Online SC 798 Sujal Vishwas Attawar and another versus State of Maharashtra and others. Stop. In paragraph 7 of Sujal Vishwas Attawar Supra, it was sustained that even after registration of FIR, proper investigation is not being carried out. In that event, remedy does not ordinarily lie in invoking the jurisdiction in the first instance, but in seeking recourse to the statutory framework, unless, of course, the urgency of the circumstances warrant otherwise. Next paragraph. In view of availability of alternative remedy, writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in pursuit of remedy.
Since a report is already prepared, if it can be filed in court, if a report is already there with my learned friend, if it can be taken on record.
Report has not been considered by the honorable.
No, his prayer is different. He's asking that since I have a report, he wants a copy of the report. But since I have not filed,
recorded, give a report.
No.
Item number 85. Under 85, I have the instruction to appear on behalf of the private respondents.
Yes.
I beg to appear on behalf of the petitioner. On the last occasion, you'll
আজকে হিয়ারিং এর ডেট ছিল বুঝলি? হ্যাঁ
বোনের বাড়ি থাকা ওর বাড়িতে যাচ্ছে সমস্যাটা এখানে
আমি সাহেবটাকে ওই তুলে যাবি
উপহার পিটিশনে যেটা অ্যাড্রেস দেওয়া আছে ওটাই। তার বোনের, তার জন্য নোটিশটা হয়তো যাচ্ছে না। সেটা হচ্ছে আলিপুর তো।
Yes, report.
Yes. My lord, I have two reports, one by the sub-divisional
Sub-divisional
officer,
officer, another by the
plus let me
police
place the report of the Kosba police station because the allegation was that why she was called by way of a phone call. So what had happened is on 30th of November 2025, the respondent number 9 had gone to the police station and and wanted to file a complaint as against the writ petitioner. So this is usual practice, lordship. When there is family dispute, the police tries to resolve it using their good offices. So in that base, on that account, since a complaint was there against the writ petitioner, the duty officer had called the writ petitioner to settle it out. Thereafter, a GD entry was made and it was countersigned by both the parties. That is there. This is the first aspect. The second aspect, lordship, the sub-divisional officer Alipur has instituted basis a complaint which has been made by the writ petitioner, FIR has also been drawn up against the private respondent number 8 and 9, the son and the daughter-in-law. With respect to the other direction, with respect to the proceedings under the 2007 Act, SDO has initiated proceedings. Two dates were fixed. However, the writ petitioner did not turn up on both the occasions. Today, as a matter of fact, date is fixed at 2 p.m. It was fixed at 2 p.m.
Perhaps what has happened, the writ petitioner has been ousted from her home and now she is residing at her sister's home. Perhaps the notice has been served in a permanent address. but
Maybe
could-
so, maybe so, and that is reflected in my police report also that she is residing at Upahar apartments. Since my learned senior friend is appearing for the private respondents,
So whether you want to go back to your own residence?
I want to go back to my own residence.
police will provide all necessary assistance.
If she wants to decide, she can decide. I cannot stand on this wavelength. But only humble.
You ought not have any say.
No, no, I have no. I cannot have.
Because it is
cannot have.
proud.
But I cannot have. I cannot have any say. Like, only humble prayer before your lordship is this. Since it's an ancestral property, I am staying over there with my daughter, with my wife. If I may also be allowed to continue into this story.
The dispute, lordship, as an officer of court, it is my duty to bring the true facts. It is not today. My learned senior friend, upon instruction, may say a lot of things. It is the dispute is not with respect to the ancestral property. The dispute is with respect to the deceased husband of the writ petitioner and his financial assets, his bank account.
That is recorded.
Yes,
in all.
and that is has been what has been revealed from the inquiry done by the police. So today, if he feels ignorance that it is only with respect to ancestral property, that is not right.
But if your lordship goes by the financial assets unit, that there are certain things which need to be indicated before your lordship unit, because all the financial assets, whether bank account, whether fixed deposits, in which the respondent number 8 is the joint account holder also. That is reflected from the books of the banks. But there are certain issues I am not.
So being joint account holder, you will siphon off entire amount by taking advantage of the fact that you are joint account holder. It appears so from your side.
There has been no withdrawal at my instance. But subject to correction, if your lordship wants to hear me, in the month of May, there was a withdrawal of 12 days.
Very well, court at
I'm
this
not
stage will
entering-
not
I'm not
enter
entering
into
into
this issue. If petitioner expresses intention to stay at her own residence, then the police authority will provide assistance.
Police
to
will
the petitioner.
provide all necessary assistance. Lordship also kindly makes a direction on the private respondents also that no untoward incident should happen tomorrow, because then the responsibility will come on the police. I have also filed the report by the SDO.
Yes. Issue. The order dated 16 June 2026. Two reports. At 16 June 26, a report is filed by Subdivisional Officer Alipur, South 24 Parganas. And same is taken on record. A communication dated 1st July 2026 of officer in charge Kasba police station is also filed and same is also taken on record. And same is taken on record. Stop. Copies of report of subdivisional officer Alipur, South 24 Parganas and communication dated 1st July 2026 of officer in charge Kasba police station are made over to the learned advocate representing petitioner and respondent numbers 8 and 9. Stop. It is disclosed in the report of subdivisional officer that a proceeding has been initiated under the relevant provisions of the relevant provisions of the maintenance and welfare of Maintenance and Welfare of Parents and Senior Citizens Act 2007. Stop. Issue was considered by the subdivisional officer on 13 July 2026 when when petitioner was not represented. Stop. Now, how the notice is to be served? Through police authorities.
No,
Because
notice
if
made.
petitioner stays if petitioner prefers to stay at her sister's residence, then she will not get notice.
Yes, Lordship. So if my learned friend can ask his client to approach the police station, police authorities today itself, the police will take steps, or tomorrow rather, because the order will get uploaded today maybe. So she can go back to her.
That she may not be found comfortable in that residence.
My lord, what I was suggesting.
She will not get notice.
Yes, Lordship. What I was suggesting, I was having a talk with him also. If he can go to the subdivisional officer's office, they will get intimation of the next date. As a matter of fact, Lordship, I don't want to say it, but I had intimated it to the advocate on record that today is a date fixed. Maybe he has forgotten about it. There's no notice, but he can go. He will get all the assistance.
Kindly
required.
mention fresh notice may be issued because today the matter can be disposed of.
When petitioner was not represented. Stop. Matter is fixed for further consideration by subdivisional officer TC on 30th July 2026. 30th July 2026 when present writ petition is scheduled to be heard. When the present writ petition is being heard by this court or when present writ petition is heard by this court. Stop. Stop. Subdivision officer is requested to fix another date for consideration of the issue.
My lord, what I would suggest, if a date could be fixed by my lord, then he's here, he gets a notice right now. Agreeable. তাহলে নোটিশের কোনো ঝামেলা থাকছে না।
Subdivisional officer is requested to fix another date after fortnight. Stop. Petitioner is directed to appear before the subdivisional officer by 7 days from date and apprise the subdivisional officer
About his present, about her present address.
for issuance of appropriate notice.
Grateful.
Stop. Next paragraph. It is disclosed in the communication of the officer in charge, Kasba Police Station, that based on complaint, a criminal prosecution being Kasba Police Station case number 338 dated 29 June 2026. 29 June 2026 has been initiated. Stop. Concerned police authority is directed to expedite the investigation and submit report before the jurisdictional magistrate. Next paragraph. If petitioner conveys her intention to stay at her own residence, in that event, officer in charge, Kasba Police Station, is directed to provide necessary assistance and protection to the petitioner, which would enable the petitioner to stay at her residence. Stop. Respondent, next paragraph. Respondent numbers 8 and 9 are also directed not to disturb the petitioner if petitioner chooses to stay at her residence. Stop. Next paragraph. With the aforesaid directions, writ petition stands disposed of. Parties to act on the server cookies. You
Grateful.
appear before the subdivision officer by 7 days and inform regarding your present address.
Grateful. Grateful, Lordship. Yeah, she.
Item number 86.
This is my prayer. This is the second FIR by one of the witnesses in the previous charge sheet.
Yes.
And one of the victims as well.
Just a minute.
My lord, my lord.
See.
জিজ্ঞেস করো প্রাইভেট রেসপন্ডেন্ট কি রিপোর্ট দিতে পারবো? আমার এফআইআর ডিসক্লোজড আছে, তুমি দিতে পারবো না তো। তুমি তো জানো তাহলে। মনে করার মতো প্রাইভেট রেসপন্ডেন্ট
Cognizance taken.
cognizance to
My lord, I still have something to pray for. Since
yes, it has been taken.
My lord, kindly
CJM
there
Barasat
are
has
two
taken.
FIRs. In the previous one, charge sheet filed, cognizance taken. Whether in this matter, this is a 2026 FIR. There's a previous 2025 FIR as well.
So have you made out a case in connection with the second FIR?
2026 matter, 2026 is if Pagoya TPS case number 228. 228, his prayer lordship is for safe
228
custody
of 20?
of 26
26.
with dated 15/5/26. Investigation is going on. He has a prayer that for recovery of the CCTV footage, CCTV footages, everything has been duly seized and no material has surfaced to indicate that the footages were tampered with. That is also, there's a prima facie opinion on that.
That was my primary prayer, my lord, and otherwise the person has been arrested.
So your writ petition is confined to 228/2026.
Only to
Not with regard to the previous FIR.
charge sheet
And that too
files,
only limited respect to the CCTV footage.
CCTV, and also to take coercive steps. That person has also
Which
been
paragraph
arrested.
you have disclosed?
Second page, third last paragraph, beginning with it is pertinent to mention.
Would kindly be pleased to see 11th of May. CCTV footage pertaining to 11th of May.
Coercive steps নেওয়া হয়েছে বেশি ছিল
Arrested.
বেশি হয়েছিল
That prayer is gone.
Issue.
Thank you for the copy.
No problem.
Mr. Das, Learned Additional Government Limited representing state respondents has filed a communication dated 21st July 2026 of Inspector in Charge Baguihati Police Station. And same is taken on record. Copy of the communication dated 21st July 2026 is made over to the Learned Advocate representing petition. Next slide. By presenting this petition, petitioner has expressed concern with regard to steps taken by the concerned police authorities in connection with Baguihati Police Station case number 228 of 2026 dated 15th May 2026 under certain provisions of PNS. Stop. It is also submitted on behalf of the petitioner that CCTV footage of a particular of a particular period needs to be seized and preserved. Next paragraph. It is disclosed in the communication dated 21st July 2026 that CCTV footage of alleged incident covering relevant time frame as per the complaint was seized by preparing seizure list without causing delay and forms part of case record. Stop. It is also disclosed that during investigation, no material has surfaced to indicate that footage was tampered with before same was seized. Stop. Next paragraph. In view of steps taken by the concerned police authorities as disclosed in communication dated 21st July 2026, no further order need be passed on this petition. The petition is disclosed now. Parties to act on the server code. Great for
The affidavit of service entry.
Every service to put it I'll put it.
Item number 87.
Well, I am for the petition. There also, my lord, the son and my lord, the son's wife, my lord, they have kicked off the parents, my lord.
Yes.
They have kicked away the parents from their house, my lord.
Kicked away.
Yes. They have, my lord, what happened, my lord? I filed a petition, my lord, directed to file a report. Then, my lord, police has done a commendable job, my lord. They have returned back to this house, my lord. And only prayer, my lord, kindly direct the police to see that.
Terminology may be wrong, but the steps taken by the police authority is correct. Issue.
Breath of fresh air.
Well, kindly consider, my lord, kindly direct the police authority to see, my lord, whether, my lord, the son, my lord.
It is submitted by the Learned Advocate representing the petitioner that both husband and wife were driven out.
Yes.
That petitioners were driven out from their own residence by the private respondent, son and daughter-in-law.
Yes.
By respondent numbers respondent numbers 5 and 6 being son and daughter-in-law, which prompted the petitioner to approach this court with the present writ petition. Stop. However, it is submitted that concerned police authorities have taken necessary steps which facilitated the petitioners to return back to their own residence. Stop. Return back to their own residence. Stop. At present, petitioners are residing at their residence. Stop. Next paragraph. In view of such submission, it appears grievance of the petitioner stands repressed, and no further order need be passed, excepting a direction upon the concerned police authorities to keep vigil so that no untoward incident takes place.
And son and daughter not.
Parties to act on the
disposed of ताकि बोल रहे हैं, disposed of except a direction.
Next paragraph, writ petition stands disposed of, parties to act on the served authority.
Great.
Day ends on a very positive note, hearing appreciation from the petitioner. The police has done a comment.
Yeah, they have done a commendable job.
Grateful.